be legal and enforceable, an agency agreement must be what? In writing between client and principal? Well, who's the client and who's the principal? Oh, they're the same person. So that's not going to work. Verbal between client and firm. No, that never works. Good job. Nobody fell for that one. In writing between agent and principal. That is true because agent is also firm. For our purposes in pre-licensing, we're going to not go with the casual colloquial term of agent meaning human, but agent meaning firm. Therefore, that is the best answer. Required elements of an agency agreement include what? Real estate license number of firm? No, even though we saw that it's on there, we are not testing you on that. We definitely need the real estate license number of broker, but not the driver's license numbers at all. All agency agreements must what? Good job. You guys are killing it. Expire automatically, not renew automatically. There is one exception, one little nuance. In a property management agency agreement, there is a possibility to let them have a renewal built into it. But all agency agreements must expire automatically. That's burned into your brains. Good job, 10 out of 10. A required element of an agency agreement allows for what? Good job. No form of discrimination ever. Why do we need agency agreements in writing? It's for us. It's to get paid, right? Otherwise, we have no proof, nothing enforceable, so to speak. It does create rules of engagement between the principal and the firm. However, best answer is to get paid. And then it's not all of the above because number 3 doesn't work. It's not rules of engagement between the seller and the buyer. Good job. Repetition helps a little bit, doesn't it? Let's try the next one. It is possible for a broker to receive compensation if another broker has an agency agreement with the same client. Look at you guys showing off bright and early this morning. Yes, procuring cause could occur because there's no police. Yeah, the real estate commission exists, but things happen and then people are caught after the fact, right? So it's totally possible that you could start working with someone, let them show you some stuff, and then whether you've signed anything with them or not, let's say you have and they did everything right, and then you went on to another broker for any number of reasons, and you started working with them and looking at the same things, and maybe that broker isn't on their A game, forgets to ask, doesn't really want to know, are you working? Have you been working with anyone? And then somehow that first one you worked with who showed you stuff finds out you bought it. Don't know how they might, but they could. Things happen, weird things happen. And then they come forward, have a dispute with the one that you ended up buying with and say, I was the procuring cause. It can get messy and all those things can come to light. So it's certainly possible for a broker to get compensated even though another broker has an agency agreement. There's nobody monitoring this stuff. As far as during in the moment, those agency agreements are not on some master database that everybody can cross-search, cross-reference. They're just sitting at the firm of the person with whom you have the agreement, right? So good job. Let's see the other one that was attempted. Let's see. No, a broker with an agency agreement is always paid. That is not the case. People do not behave themselves. That's why we need things in writing. We need agency agreements in writing. But even with that, one of your stock questions you should always ask when somebody is talking to you about employing your services is, oh, have you been working with an agent? And then the best part of that question is the silence that comes afterward. And if you're in person, all the better. Look at their eyes while you're asking, because then they might do those weird things like, well, no, and frowns and stutters, and it means that, yes, they have been. They're just not sure what you mean by the question, and is it going to jam them up, right? And they lie. Not all of them, but some of them, the ones who have things to hide. I've had them where they called me on my own listing, 7 o'clock in the evening. That's fine. I chose to answer the phone. No big deal. Oh, I want to see this house tomorrow. You're listing tomorrow. No, I don't have an agent, because I always ask. The next day I get a call from not them, We had set up the appointment to go show it to them, but some other person turns out I'm their agent. Oh, well, they didn't tell me they had an agent. I specifically asked. Well, they do, and I'm not hurt about it. It's just annoying, right? I'm all geared up to go there and do the whole dual agency thing, possibly explain things, and even have set aside time. And then here I find out they have an agent. That's what happens. It's just what happens. You have to be flexible. So nope, no guarantee with that agency, but you could. And then the other question is, you and your firm and your BIC have to decide if you are the losing party and you have the justification and the signed agreements and stuff, do you want to go after them for it? Business decision. Do you want to have the reputation of suing your clients or pursuing your clients for money? Maybe, maybe not. Depends on just how egregious they might have been. I've never done it. I'm assuming Margie's not been in one of those. People usually just let them go, move on to the next one. It's a numbers game, guys. Just take it, chalk it up to a learning experience. Get on to the next one. If you have so little business that matters that much, you don't have enough business. You need to work on getting your business skills, your skills at getting more business. Think of it. When you get in those situations and you're just wallowing around in the misery, think, would I care as much if I had 20 more clients waiting in line to work with me? And if the answer is no, then go work on finding 20 clients to be waiting in line to work with you. That's your problem, not that one jerk that did you wrong, right? That's the boot camp tough talk speech. It's just the truth. When do we actually earn our commission? Oh boy. Here we go. When do we earn it versus when do we get paid? When closing occurs and we receive the funds, well, that's when we got paid, but that is not necessarily when we earned it. If we procure a ready, willing, and able buyer, that's when we earned it. We're not getting it. We're not receiving it in that moment because it could be a week or 2 or 3 before closing. Produced a ready, willing, and able buyer. The buyer came along and now it takes 30 or 45 days to closing. Are they able? Probably not. They're definitely ready and willing because they came and made an offer and it got accepted and we're under contract. But if they're getting financing, we still have the loan process to go through to determine whether they are able. Therefore, if it did fall apart during the loan process, approval process, and you decided to pursue them, go after them and say, hey, I brought you a ready, willing, and able buyer, you should pay me the commission. Well, the test would be, were they really able? Did we have proof that they were able because they didn't get their loan approved yet? It fell apart before that step. So that would be kind of what would be looked at. Let's see. You didn't fall for the next 2 when agency agreements are signed. Certainly not. We've not earned anything then. We've just earned the right to work for them then. When we bring a qualified buyer who agrees to everything the seller wanted in the listing agreement, or when we bring a qualified buyer and the buyer-seller agree to terms and sign a contract. Yeah, that's better. The contract is stronger than the listing agreement. So 4 or D would be the best answer here. In the event of a brokerage fee conflict between firms, the correct course of action would be to contact, guys, I would put money on you seeing some version of this question. They're going to want you to know who you go to complain because they being the real estate commission, because that's who this course is all about. They don't want to be bothered by disputes between brokers. Don't call them if you have a dispute, a brokerage fee conflict between you and another broker. They're not here to referee you with another broker. They're here to make sure you took care of clients. So, first choice, absolutely 100%, 180 degrees from the right answer. That is not right. The commission is not there to manage conflicts between us, period. Write it down in your notebook. The commission is not there to manage disputes between brokers. Local MLS board, local National Association of Realtors board. The best, it'd be the real local realtor board. That's the best answer. Local MLS. MLS is all about the multiple listing service. They're not concerned too much between brokers. They're just making sure that you adhere to the rules of the MLS. Now, if you put in a violation, certainly a fair housing violation or some sort of there's this thing called coming soon status, and if you do that wrong, there's certain time frames involved, then they'll get you, right? They'll warn you about that and have a problem with you. But that's not the case here. We have a brokerage fee conflict between firms. That's all about the local board. Go to the local realtor board, and they will set up some sort of an arbitration hearing so that you can plead your case, they plead their case, and then they rule on it. Sword fight at dawn. That'd make things more interesting for sure. If we could film it, put it on YouTube or something. If a broker has a license on inactive or expired status, well, let's pause for a moment. And just like when you're looking at these yourself, I'm going to send you practice exams today. Even though we haven't got to the midterm yet, most of those exams will be useful to you. You can just ignore the questions on finance and contracts if you want to, but at least you can start getting your feet wet on taking practice questions. So when you're reading those questions, get your money's worth out of those free practice exams, meaning wring them dry, like make questions out of each question. So here, pause. Let's think about and review real quick. What does it mean to be inactive? What did you do wrong so that your license became inactive? Tell me in the chat. That's another one that's a big, high priority, high likelihood of being asked on the test. What is the difference between inactive and expire? There you go. Good job. Let's see. Shane, Janina. Yeah. Inactive, write it down. Inactive is about education. You didn't do your education. It's not about the money. It's about the education. Expired is about the money. Think about a parking meter. What happens if you don't put enough money in it? It shows you the words expired, especially the old ones. A little red flag says, it pops up, says expired. Expired license means you didn't pay your $45. And by the way, when is that $45 due? When is that due? There it is. The day before the license year begins, which is June 30th is the last possible day because the real estate licensing year starts on July 1st. Another good one to write down. July 1st, start of the real estate license year. Happy New Year in real estate, right? So June 30th is the drop dead last date to pay the money. But then there's a little nuance about the education. Your license becomes inactive when you don't take the CE, continuing education, by a certain date. What date is that? There it is, TWE. The 10th of June. Weird, arbitrary. Why? Well, essentially because the Real Estate Commission needs a minute to take a breath to get ready for the new license year. They give themselves about 20 days. They give themselves from 6/30, June 11th to June 30th to collect themselves, process the last few people that have passed the CE and completed the CE, and just reset. So if you don't take your CE by June 10th, here's the next question to write down. If you don't take your CE by June 10th, what happens to your license status on June 11th? Is it inactive? Does it go inactive on June 11th? If you don't finish CE by June 10th, does your license go inactive by June 11th? Look at you guys showing off. You are smarter than everybody in CE that I taught yesterday. Maybe not all of them, but many of them got this wrong, guys, and they do the business. This were a mix of people in business a year and then up to 20 years. I don't know who answered right or wrong when I asked this question then, but some of them didn't realize or think about it. Now, good for them. They clearly haven't ever been inactive, so they're doing something right. But that's an easy one to miss. June 11th, you're still active. You're still active all the way up until July 1st is when you will become inactive. So you see the train coming. You know that you need to fix something and you have 20 days. Well, you can't do anything about it at that point. June 11th rolls around and you're inactive, and you're going to be inactive. You didn't take your CE by June 10th. It's going to happen. You can go ahead and schedule a class for July 1st, but you're going to be inactive on July 1st, period. And it's not a matter of having it fixed and being active again within a day or so. It might take a little bit. It might even take a week, because you can take the class on July 1st if you can get in, because there's a whole bunch of people in those classes with that deer in the headlights look. They're all panicky and kind of grumpy and sad because they had to pause their business because you can't do business anymore when you're inactive or expired. And that's the next question. What's the next thing you do if your license becomes expired or inactive? What's the very first thing you do after your license goes inactive or goes expired? Next step, very next step. You guys are impressing me today. I'm feeling really optimistic about you. Good job. That's it. Everybody skips over that step. They think, oh, we gotta take the class, or we gotta pay the money. No, first of all, you got to stop doing real estate, because that would be illegal. You don't have a license anymore. Good job. Those of you who didn't think of that right away, write that down. It's an easy one to get, and it's an easy one to miss. So you're going to get it now because you're going to write it down. Okay. Now that we've gone over inactive and expired, if a broker has a license like that, they may still receive a commission if what? If they had a valid listing agreement in place while they were active. Well, the listing agreement doesn't get you paid. If they had a valid buyer agency agreement while they were active, also doesn't mean you had a contract. You didn't sell anything yet. So that's not going to work. They had a valid contract in place while they were active or never. Brokers must have an active license to receive compensation. It's actually best answer is C, because there is a way that you could actually get paid while expired or inactive, but only if you did all the work while you were still active. If you earned the commission while your license was active and then it goes inactive, on those transactions or that transaction, you could still get paid. Was it active when you earned it? It's a little nuance there. Short and sweet review on 8 today. Let's get on into 9. Okay. All right. Still highly important. Still a ton of questions coming out of this one. And it's about contract law. It's also something that could show up on national as well as carries over into state when you get into 10 especially. But basic contract law, now we're talking about not the hiring so much anymore, but the going under contract, offers and acceptances. And that's a point of confusion in the business all the time. People not understanding when the contract actually got accepted and therefore went under contract. When the offer got accepted and you went under contract? Because sometimes people change their minds and they want to back out and they think, well, it never got accepted yet because I didn't hear back from them. It wasn't communicated. And some people don't understand how that works. So let's start at the beginning. We're going to cover some level 1, the definition of bilateral versus unilateral contract. You might get some idea of what that's going to mean because bi means 2 and uni means 1. Auction sales, we'll talk about that. You could utilize auctioneering to sell your properties, but you're going to need a broker license, which is what you're accomplishing here, but you're also going to need an auctioneer's license. That's a separate thing that we don't do, but you have to get that elsewhere. But it's possible. Level 2, contract terminology, understanding what means what. Valid, void, and voidable, the V words, the 3 V words. Other words that kind of fit in with those called enforceable and unenforceable. If it's a valid contract, it's enforceable in a court of law. What's the difference between addenda and amendments? We'll get into that, as well as essential elements of a contract. Remember, we talked about essential elements of a deed. Now we're going to talk about essential elements of a contract. Requirements for this thing called reality of consent, which is part of those contract elements. And then level 3, an analysis item, mutual assent. So contract, what is it? It's a promise. Contract is a promise to either do or not do something. Legally enforceable. That means Judge Judy is sitting there saying, okay, you're saying that you promised to sell it to them. Okay, show me proof. Where is it in writing? Oh, I don't have it in writing. We shook on it. Gentleman's agreement. His word should be his bond. I don't care. It's a courtroom. It's not enforceable. Get out. Really? Enforceable means can you back it up in court? Is it enforceable in a court of law? No. In that case, no. Legally enforceable promise to do or not do something. That brings up these two words. An express contract versus an implied contract. Every single one of you, at least I would bet in the last week, maybe at least the last month, have engaged in an implied contract. You've all engaged in an implied contract. Any guesses as to what I'm talking about? Might have already stolen my thunder on this one, but good review. Who else? Keep going. Good job. When you go to that restaurant, when you go in that store, they don't ask you for a proof of funds letter from your bank. They don't ask you for a pre-approval loan letter. They just assume that since you're there and since you're filling up that buggy, is it buggy or is it cart? I don't know why I said buggy. I always say cart. Who says buggy? What's that thing called at the store that you put stuff in? Buggy, got one buggy. How many buggies? One buggy? I know. English and the Northern. Yes, that's good. The rest of us are cart people. We're all cart people, the rest of us. Okay, good. When you fill up that cart or when you fill up that table with stuff you ordered to eat, they're going to bring it to you. Or they're going to let you load it up. But then it's a case of, can I wheel this cart out to the car quicker than that store security guard? Can I get out of this restaurant on a full stomach? Or did you intend to eat but also pay for it? That's an implied contract. Because of your actions, they assumed you're going to pay for it, right? Express, what does express mean? You tell me. Good job, guys. You all get gold stars. A lot of people say only in writing, but it's not only in writing. Express means intended, intentional. It could be an oral agreement that was an express agreement. You verbally or in writing said what you intended to do. That's the difference between that and implied. Implied is based on your actions and assumptions. Express is intended, intentional. This is what we're going to do. Whether you said it, spoke it, or wrote it. That is the difference. Sorry, I'm setting a little reminder for myself. Okay. Express, stating the terms, orally or written, either one. Implied is sort of a mystery. It's like, well, she's acting that way, so it's sort of like dating. Well, he's acting that way. He texted me 3 days after the date. I'm assuming that means something. Nope. Implied. You're dealing with implied stuff based on actions and conduct. That's not going to work out too well for you. Unilateral and bilateral. Uni means one party is making promises. Unilateral. Only one party is making the promises. Bilateral means both of them are. An offer to purchase is an example of a unilateral contract. You've got a buyer or an offeror, maybe not necessarily a buyer, by the way. The one making the offer, because sometimes in a different market, if a seller is really desperate to sell and getting a lot of showings, but no one's making an offer. And they say to their agent, well, what's happening? Why am I getting 10 showings this week, but nobody's making an offer? I got to get this thing sold. And one of those people have looked at it 3 times. Why don't they make me an offer? And what you, as their listing agent, could say to them, why don't you make them an offer? So you could encourage and suggest your seller to make an offer to that buyer. Sometimes buyers just think, oh, they're asking $350. I'd pay $330, but not $350. I don't want to insult them with an offer like that. Not knowing that that seller would be thrilled with an offer like that because maybe they chose to put that much cushion into it, which would be a problem in and of itself. And that's kind of why they're in that situation. They probably shouldn't have had that much cushion. Probably shouldn't ask that much over what's the real value. But a seller could make an offer to a buyer. And in that case, the seller would be considered the offeror, one making the offer. But usually it's the buyer. And usually we're talking about the offeror being the buyer. So the buyer's promising something, promising to do something. Seller is not obligated to accept that offer, right? That's the process. Seller's going to either accept the offer that was promised or say, nope, I do not accept it. I reject it, but here's a counter proposal. Here's a counter offer. Or just flat out no. I'm not even going to dignify that with a response except no. Back to that counter offer thing. So here's another one to write down. What is a counter offer? A counter offer is first and foremost a rejection. You're rejecting the initial offer. Counter offer kills the original offer. It's gone. You cannot go back to it either. We'll get more into that in a moment. Counter offer is a rejection and then a counter proposal. Don't forget the part about it being a rejection. So unilateral, one party is promising stuff. Bilateral is a classic case of a contract. Now, the buyer, you're not offering anymore. That offer has been accepted. So now we are under contract. Now that buyer is making a promise to actually bring money and pay for the property. In exchange, the seller is promising to give them the property in exchange for the money. And there are other promises built into all that along the way. But there are promises held over both of them. They both have made promises. I promise to pay versus I promise to perform. That is bilateral. A couple more words, and these are words that when you get a license, get brand new, and go into that firm, you could, but I don't advise you do it because you don't want to make enemies, you want to make friends, but you could probably catch some of those old, aged, veteran real estate agents on a technicality. And you'd say, hey, I'm so excited. I just went under contract. And they might say, oh, so you have an executed contract. Executed means signed by both. Well, no, I'm sorry, old agent that should know everything. No, what I actually have is an executory contract. The word executory means there's still stuff left to do. You're not done yet. In other words, you haven't gotten paid yet. We're not closed on it yet. And executed would mean you're all finished. It's closed. But people use the word executed all the time while you're in the under contract phase. They said what they mean is the contract has been signed by both parties, therefore it is an executed contract. But it's more about the promises than the signatures. So on this test is the last time you'll need to care about the difference here. But know that executory means you're in that under contract phase. There's still things left to be done. Executed means nothing's left. You've just closed. Now you get your money. Congratulations. Executed means you're done. Executory means you're still working on it. Under contract versus closed and recorded, in other words. True or false? An express agreement must always be in writing. True or false? Express agreement. Must it always be in writing? We just talked about it. Good job. Good short-term memory. Well done. Express just means intentional. Means you're talking about it, whether writing or verbal. Oral or written. All right. you might have seen these in the chapter as you read, and these are the 3 V words: valid, void, and voidable, with regard to the status of the contract. Is it a valid contract, void, or voidable? Whether it is valid or void or voidable comes back to this enforceability concept. Is it enforceable or unenforceable? So all of these words are some things that they could write questions about. Valid, as I'm sure you've already guessed, is the best one. That means everything is satisfying the legal requirements, and it is also enforceable. You could go to court over it, show them the written contract, and prove your point, because it's all right there in writing. There's no problems. Got a written contract, and there's no issues with it. Either the written instrument itself, the instrument being a legal document, that's all that means. And there's no problems with the parties themselves. What sorts of problems with the parties? Parties meaning the people. What sorts of problems with the people might there be? What are we talking about when we say people problems? 3 things. 3 things. We'll figure out the financial ability later, but that's a good guess. Married certainly does present problems. People don't admit to it. There it is, Shane. There's one of them. Incompetence. Incompetence is one. What's another? So I'm a YouTube junkie. I watch and deep dive, go on rabbit trails. And at one point in the last few years, I found this kid who jumps off of his house onto a trampoline. And pretty impressive and scary. And he had 10,000 subscribers when I found him. And then a year later, when I tuned back in, he was up to like 1 million. He was at 17 years old at that point. He started spending money. He bought a sports car for $160,000. If that 17-year-old kid came here, wanted to buy my house, can I sell it to him? Can I sell my house to a 17-year-old kid? Yeah, I could. Would I be at risk? It goes back to this concept of voidable, because we'll talk about what voidable means in a minute. But because he is less than 18, there are some risks that I have to face because he is potentially in jeopardy. Yeah, he could walk away from the contract at any point and there's nothing I could do about it. It's not enforceable upon him because he's less than 18, less than legal age. So that's the second one of the 3. Incompetence, lacking mental facilities, underage, and then also sober, impaired. Thank you, Jennifer, just in time. 18, sane and sober is a quick way to say it. Write that down. 18, sane and sober. Those are the 3 that have to do with competency of the parties or problems with the parties. Were they 18 or more? Were they sane when they entered into the contract? Were they sober when they entered into the contract? How could sober affect them? You go out looking at 14 properties on Saturday, you find one, you take your client to the bar and grill restaurant to write up the offer, and by the time you're finished filling in the blanks, doing the paperwork, they're a picture in. They've had a whole one all to themselves. They're a little extra happy, and that's the point at which they sign the offer. You present the offer, it gets accepted, happy days, thrilled. They write you a couple of checks, you give those over. The next day they call you and they say, "Did I buy a house last night?" You're like, oh no. Because you know what? I was thinking, I'm not sure if I like that one as much as I thought I did. Because they signed it while not sober, that is an avoidable contract. That could be a problem, right? Another example of the incapacity of parties is this, and this was a true story. Not with me, but with someone. This elderly gentleman walked into the real estate office, said all the right words, knew everything to say. Wanted to buy something. Agent got excited, put him in the car, drove around, found something, picked it, made an offer, wrote an earnest money check. He did. And it got accepted and great, under contract until 3 days later when a younger but still adult woman walked in and asked for that agent and said, "Did so-and-so come in here the other day?" "Oh yeah, Mr. Smith. Yeah, we bought a house." "Well, kind of not, because I am the legal guardian for his affairs because he has dementia, early onset dementia. He was a real estate agent for 30 years, so he knows the lingo. That's why it sounded like he knew what he was talking about. And I watched his checkbook and I saw a check come through for $1,000, and yeah, we're not doing this." Right? 18, sane and sober. That's how that could play out in the real world. So valid means there's no problems with any of that stuff. No problems with the written contract itself. No problems with the people involved. You will perform. You take a valid contract to court because somebody's arguing with you about it. As long as all of it's proven to be valid, it is enforceable in a court of law. Void has to do with the paperwork. And you could say it this way. Void means there's a problem with the paper. Void means there's a problem with the paperwork. Voidable means there's a problem with the people involved, 18, sane, and sober, somewhere in there. So we're talking about void. There's an essential element required in a contract that is missing. It lacks one or more essential elements. It is not enforceable in a court of law. A void contract, it could actually successfully close, by the way. You could have a void contract, but everybody still shows up to closing and goes through with it. It's just that the whole time during the under contract phase, either of those parties could have chosen to back out. There's nothing the other one could have done about it. Pause to let that sink in. I feel like most people would have gotten that question wrong had I asked it. But void means you see void and you're like, oh, that just means it's gone. It's dead. No good at all. Well, it's void. It lacks an essential element. Therefore, it's not enforceable. But here's a scenario. A couple old farmers sitting on the back of the tailgate of the truck. They look out over each of their own land, their neighbors. They each own 100 acres backing up to each other. One of them's older, and he says, "Look, I want to scale down a little bit. I'll sell you 50 of my acres." The other one says, and he's not as old, but he's still older, and he says, "Okay, sounds good. Yeah, I'll do that. Let's shake on it." They shake hands. They never write it all up. And they say, "We'll tell our attorney, buddy, and then let him tell us when to come down and make it official." So no offer is written, nothing, no contract is in writing. And then the next week, one of maybe the older guy says, "You know what, I was thinking I should have run this by my kids. They're mad at me that I'm selling 50 of the acres. They want me to give it to them when I die. So therefore I'm out." And because there's nothing enforceable, nothing in writing, there's not anything his neighbor can do about it. "Well, your word is your bond. Why are you going back on your word?" "Take me to court. Judge Judy's not going to agree with you. I'm out if I want to be out." That's what void is. Along the same lines, the younger one could have said, "You know what, I wanted to buy your 50 and I still do, but I forgot we're trying to put the kids through private school. They want to go to private college. Therefore, I can't do it. I'm not going to do it." "What? Now I got to find another buyer? I'm mad at you. We're going to court." "Okay, take me to court. You're going to bring a written contract?" "I don't think so, because there is none." Right? Either one could back out along the way. But on a happy note, they could actually both show up to closing and close on it. One brings the money, the other brings the deed. They sign the deed over. It'd be a newly written deed. Deeds given in exchange for the money, and now we have a completed closing that was void the whole time. I know, that's weird. It hurts your brain, but just write it down. Void means that either one could back out along the way. There's nothing that either could do about it. It's not enforceable. You never even had a contract. Essentially, if it's not in writing, you never even officially, legally for purposes, had a contract. That's void. And then voidable means there's a problem with the people. The document looks good, the paper's good, but it can be rescinded because one of the parties is either a minor, intoxicated, or mentally ill. And in that case, that person who is either a minor, intoxicated, or mentally ill, or a mentally ill, intoxicated minor, that'd be a triple threat. You don't have to close if you don't want to. You could back out. And there's nothing the other person could do about it. So one of the parties could back out, but not the other one. That 17-year-old trampoline kid buyer could choose not to buy it. I'm just 17. Why did you pressure me to buy your house? And there's nothing I could do about it. If I try to back out, though, he could do something about it. He could say, nope, I've got a contract here. You wrote it. You signed it. We both signed it. It is executory, by the way, and I'm holding you to it. So he could hold me to it, but I can't hold him to it. It's one-sided. Voidable is one-sided. Void is two-sided, meaning either party could back out and there's nothing either one could do. Voidable means one of the two parties, the one who is either 18, not sane, or not sober, could back out. You don't have to close if you don't want to. When we come back from break, we'll talk about unenforceable. I'll see you at 10. See faces. Okay, we're good. Okay, unenforceable means we could, it has valid elements of a contract. We could still close. It's just that if you took it to court, you wouldn't be able to, the judge would not look favorably upon it. However, you could still end up closing. It's not in writing. Neither party can sue for performance, something called specific performance. Suing for specific performance is something you would do to a seller, by the way. Write that one down too. We're going to get to that more later. But if a seller goes back on their promise spelled out in the contract, in other words, if they breach, can't hear. Anybody else? Can't hear. Oh, son of a gun. Did that yesterday or the other day. I'm sorry, guys. Okay. That's frustrating. That's a rookie move. I know better. It's what it is. I'm gonna weasel out of it. I've got a mute on my little mixer over here, and sometimes I don't think about the other mute. That's my lame excuse. Okay. Unenforceable. None of what I said was important anyway. Unenforceable means you could still close. Has elements of a valid contract, but you can't prove anything. In a court, the judge is not going to back you up, right? Judge is going to say, show me it in writing. The other thing about it is neither party can sue the other one. And when it says neither party can sue for performance, there's a remedy available to a buyer when a seller breaches the contract. If the seller backs out on their promises that they agreed to on the contract, the buyer could sue them for something called specific performance. And that is the remedy available to the buyer for when the seller breaches. There's a different remedy available to the seller for when a buyer breaches, and we'll get into that later. But suing for performance, and then unenforceable, not enforceable between the parties, right? By the way, you could still close. It's just that you're both at risk, right? Either one could back out. There's nothing holding either party to anything. It kind of makes me think of how the agency agreement, like a listing agreement, is there to make sure you get paid. If you decided, if it were allowed, it's not allowed, but if it were legal and allowed for you to list a house without it in writing, then the whole time you had that and you're spending your time and money, you're at risk of them at any point saying, I'm not doing this anymore. I'm not going to pay you. There's nothing you could do about it. Sort of makes me think of that fictional scenario. That is not possible, again, because you have to have a listing agreement in writing, but there's nothing enforceable between the parties. The judge is going to say, show me the contract. By the way, a contract doesn't have to be 14 pages approved by the Realtor Association or even written by an attorney to still be considered legal. It could be written on a napkin. And as long as it's got certain elements and it's between a buyer and a seller, it is a valid contract. We tend to use that one that I put in Google Drive called 2T, standard form 2T, offer to purchase and contract, because it's got a lot of language in it that makes it fair between buyer and seller, right? It's written to benefit them both relatively equally. It's balanced between the parties. Conversely, if you go buy a new construction home, that builder will not use standard contract form 2T, offer to purchase and contract. They're going to use the one that they paid an attorney to write for them. And that's why instead of the 15 pages of the 2T, it's more like 40, 50 pages. All of those pages geared heavily toward benefiting, favoring the seller, builder, as opposed to the buyer. Some other definitions. These are two that are easy to miss, but it's all in the first three letters. An addenda is something you're adding to. But what are you adding it to? You're adding the addenda to the offer. You're adding it to the offer to purchase. Now, let me show you something. Here we go. Here's the offer to purchase and contract, the standard form 2T. Offer to purchase and contract. It's got 15 pages. Now, side note, I bet it would only have 13 pages if it didn't have all these blue boxes in it, but I like them. I like the blue boxes, and you will too, because they pretty much walk you through every piece of it. So whether you're brand new or you've been in a while and you're just rusty, it's kind of a helpful thing. Oh yeah, I forgot. I need to use an additional provisions addendum. They throw these little hints. Oh, hey, you're filling out this part of the contract. Well, the offer, then you might want to also use this. So it's got all these helpful boxes. But 15 pages, it can't possibly contain every single possible nuance and possibility that every buyer would ever want. Then it would be like hundreds of pages. So the 15 pages pretty much cover the gist, and it's good enough for most and many buyers, but there's a section that we'll get to in a moment. There it is. This section of the standard form 2T has a place to identify that there is extra stuff included. This is the addenda section. And the most commonly used addenda, what is that, like 11 of them? Additional provisions addenda, I'll show you some of these in a little bit. The FHA VA Financing Addendum, which is required. Well, it's what you need to use when you're getting an FHA loan or a VA loan. There's a lead-based paint addendum, making sure everybody knows the house was built before 78 and therefore might have lead-based paint under there, somewhere under there, right? And therefore could be a concern. These are things added to the initial offer. Addenda are added to the initial offer. Because, oh, and by the way, if it's not an addenda listed here, you can check this box and put in whatever addenda you need to add. It's just that it needs to, as you see here, they're giving you an answer, giving you a hint. Identify, it doesn't say other addenda, it says, it used to, but now it says identify other attorney or party drafted addenda. What they're saying here is, hey broker, don't you write an addenda. Not allowed. That would be practicing law without a license. We are not allowed to write addenda or amendments. What's an amendment? An amendment is something you add to a contract. You're already under contract, you need to change it. Amendments change elements of a contract once you're under contract. Because the name of this form is what again? It's a twofer. It's an offer to purchase first, and then if it gets accepted, it becomes a contract. It's both, either or as needed. Starts its life being an offer to purchase like a caterpillar. Then it blossoms into a butterfly when both of them sign. I know, corny, but you might remember it. So it's an offer to purchase. When it's an offer to purchase, what you're going to use to add conditions to it is the addenda. But when it becomes a contract, what you're going to use if you need to make changes to it once it's already a contract, those are called amendments. What might you do? What's an example of changing something once it's under contract? Well, you're under contract. One of the conditions of that contract is telling the buyer, look, you have the right, if you want to use it, to get it inspected. Once the buyer has an inspector come look at the property, it might be that based on what they find, the buyer isn't as excited about it anymore. They want to make some changes. They say, oh, wait a minute, I thought it was great, but now I find out it's got a significant termite damage problem. It's got mold, it's got radon, and therefore that price I promised to pay you in the beginning that you agreed to, now I'm not so fond of paying that price because now these are other issues. So if you want me to stay in this and continue forward and still pay you that price, you're going to need to fix the termite problem, seller. And Mrs. Seller, you're going to need to get rid of that radon and do a remediation for the radon. So therefore, let me give you a due diligence amendment saying, yeah, we'll still go through with it if you fix the following. Refer to the inspection report. Fix these items. So that's how an amendment could happen. It could also happen because maybe the seller says, well, so the problem is windows and we're 2 weeks from closing and you want me to replace the windows? Well, they're back ordered. It's going to take a month to get those in. You don't want to delay the closing a month, do you? Well, then let's just change the price. Or I know one party in this room just shuddered alone. He's like, please don't change the price with 2 weeks to go. Better than that, let's get closing assistance, some closing costs paid by seller to the buyer instead of getting the windows fixed. Since you don't have time for the windows, let's just let the seller legally, without committing loan fraud, well documented with an amendment, change the closing costs. The seller can pay some of the buyer's closing, or all of them, the buyer's closing costs. That's a frequent, common way of fixing a repair issue, handling, I should say, a repair issue. Instead of fixing it, just give them money so they can fix it themselves later. I like that better as an agent because I'm like, the one who's going to live there after all this is done gets to have some say in the matter rather than the seller. You know what a seller's going to do. If they're in charge of fixing it, they're going to try to get it fixed for as cheap as possible, right? There's a difference between a Cadillac version of repairs and a Chevrolet Cobalt version of repairs, right? No offense to the Cobalt. Price points. So an addenda adds things to the initial offer to purchase. Amendments change terms once you are under contract. It's easy to mix up. And I just think of ADD and addenda. You're adding things. And agents who are in the business and have been for 10 years get these words wrong. But these are easy points to get. We'll talk more about these actual forms. We'll see them and I'll show them to you when we get to 10. And so to recap, whether it's a void contract, a voidable contract, or an unenforceable, if any of these words are true of the situation, doesn't mean that it's dead. The parties could still move forward. It just means who could potentially walk away without anybody being able to say anything about it. That's the only difference. With a void contract, both parties could walk away and the other one could not enforce it. With a voidable contract, one of the two parties could walk and there's nothing the other could do about it. That's the example of whether it's being the one party is either not 18, not sane, or not sober. And in those cases, there's some version of unenforceability going on. They could still be honored and closed. The parties could still show up to closing and give money in exchange for the deed, ownership of the property. Key word for determining if a party to the contract has created a void or voidable contract is what? Okay, we haven't talked about this. So Let me ask you this question first. If it's a situation where the person is mentally incapable, what kind of contract is it? Good job. Voidable, problem with the people. Because mental instability, 18, sane and sober, the sane part. All right, here's the nuance. Here's the little asterisk, right? If that mentally unstable person is not just because it's medically determined, but because a court of law has said, okay, you're at such a point mentally that I'm appointing this person as your guardian, that changes it. If that has happened, court appointed, legally declared, the term legally declared, in unable to handle their own affairs, if it's been legally declared by a court of law, then it is not considered a voidable contract. It would be considered a void contract. Write that one down because they'll ask it of you. Normally, you're exactly right. Voidable is when one party is mentally unable. But if it's a legally declared situation, not just a medical one, the doctor said, therefore, now the son and daughter are kind of helping him out. But if it's legally declared, then the contract status is called void, not voidable. So the key word for determining if a party to the contract has created a void or avoidable contract, which one is it? Key term, the key phrase is legally declared. Did a court of law say so? If a court of law said so, then answer the question as if it were void instead of voidable. A little recap here. You thought you were done with it till the exam, but here's a review. Which of the following would be considered a non-inheritable estate? Which of these is non-inheritable? Let's look them over. Let's go backwards. That might give you a clue. Estate for the life of another. Pour aut vie, or pour autre vie, whichever way you want to say it. Estate for the life of another means that some other third party's life is the one who is the measuring life. And the one who has bought it or gets it is the life tenant. If they die, though, they could actually leave it to they could leave it to their heirs because it's still depending on that third party life of another person as the measuring life. So that's inheritable. Estate for the life of another is an inheritable type of estate. Defeasible with a condition subsequent. I hope what's happening in your brains right now is the same for you as it is me. I'm seeing the diagram in my head, right? And I'm thinking everything on the left on that diagram was fee simple absolute, and then fee simple defeasible, and then for the life of another. All three of those were all on the left, and those were under the inheritable column. Then there was only two on the right that were under the non-inheritable column, and those were conventional life estate and marital life. Therefore, you got it. Everybody got it. A, conventional life estate is non-inheritable, but why? Because the measuring life is the same person as the life tenant. Once that life tenant dies, they are also the measuring life, so the estate goes away from them, and therefore their heirs, their estate. They can't leave it to heirs. So it's A. The broker in charge of Look at Us Realty has an unlicensed assistant who has recently completed the pre-licensing course. The assistant may lawfully perform which of the following services in return for an hourly wage paid by the broker in charge? Oh, sorry. Thank you. Good job. Submit listings and changes to the MLS for agents affiliated with Look at Us Realty. You got it. Prepare agency agreements if they do not do more than 10 a year. There's no such thing. There's no more than 10 a year thing at all. That's fictional. With the broker in charge's permission, communicate offers and acceptances for contracts involving clients. No. Hold open house for one of the firm's listings for a sick broker of the same. The thing is, it just says completed the course. Didn't say that they're licensed. An unlicensed assistant clearly says they are unlicensed. They finished the course, but they're still unlicensed because they haven't taken the PSI and passed it. So you would have wanted to key in on the fact that they are unlicensed. The completing the course was a distraction and irrelevant. Just because you're done with the course on October 26th when you take and pass this final exam, you still can't do real estate yet. Now it's just that you can schedule the PSI exam. Once you pass that, you still can't do real estate yet because they're going to give you an inactive provisional broker's license. But then once you go to a firm who has decided and agreed to hire you and become an affiliate of that firm, now you're a provisional broker on active status, and now you can do these other items. Now you can go hold an open house. By the way, unlicensed people cannot hold houses open because the chances of a potential buyer coming in there asking you questions that you're not allowed to answer is too great. You can't show houses for sale. You can't hold open houses. You would need to have a licensed person there with you. You could do that. You could kind of watch, see how they do it. But as a newly licensed, active licensed provisional broker, you will probably do some open houses. You'll probably ask agents who have listings in your firm, may I hold that listing open? Because you're trying to possibly get some buyer leads. There's a very small, like 1% chance that when you hold an open house, that it's going to find that right buyer, right place, right time, right house, right financing and ability, and it's going to actually sell. We don't do houses. We don't hold open houses for the reason that sellers think we do. We might sell their house with it, but it's such a low likelihood that we're going to. But why spend the time on it? Well, some say that it's still not worth the time, but others say, well, at least I'll meet some people. Maybe some neighbors will come in who might want to list their house too. Maybe some buyers will come that I could end up working with, and they don't buy this one, but they buy something. That's why agents spend their time on open houses. And they also kind of brag about them to the seller clients because sellers don't know any better. They see it on HGTV. They think that's a valid and reasonable way to spend your time to actually try to find a buyer for their house. But there's many, many better ways to find buyers for houses, for specific houses, than holding one open. Which of the following is allowed under North Carolina Commission Agency rules? Which one's allowed? Okay. I've got some C's and I have some D's. You're right. It's one of those two. I'm going to give you a chance to rethink it and tell me again. Is it C or is it D? And you know what? This is the conversation that will go through your own mind. As you're going through, you'll be like, A and B, clear no, easy. It won't be hard probably for most questions to rule out at least one, if not two. But at least you got it down to a 50-50 chance. But then those last two is what's going to drive you crazy. And you might think, oh man, I don't know. So you're just going to need to reread carefully those answer options. Read the question over again and think, okay, am I reading too much into the question? Am I thinking, yeah, but, and then adding my own? No, just go with these lines. Which of the following is allowable under North Carolina Commission agency rules? Let's see. A buyer agency agreement may be oral provided it is express and reduced to writing before acceptance of any offer to purchase between buyer and seller. Or a buyer agency agreement may be oral provided it is express and reduced to writing before preparation of an offer to purchase. So those two choice differences come down to, is it acceptance versus preparation? And I think most of the C's changed to D correctly, because it is, in fact, must be reduced to writing before you prepare the offer. You don't get to prepare the offer, submit it, and then have the luxury of reducing the oral buyer agency to written sometime before that other party accepts it. It better be done before you write it, before the preparation of the offer, not before the acceptance of the offer. Good? Good job. According to Real Estate Commission license law and rule, designated dual agency could be practiced between all of the following except who? Which is the one case where you're not allowed to engage in designated dual agency? What two parties are not allowed? Good job. There were agents yesterday who got this wrong. The entire second section of the this year's continuing education course is about dual agency. Clearly because the commission thinks everyone needs a recap because we're not doing great explaining it. First of all, don't let the test question wording throw you. When you're reading the question, think, is this question asking me for what the rule is or asking me for what the rule is not? So be looking for the word accept. So could be practiced between all of the following except. So you passed that test. Good job. But A, provisional broker and non-provisional in the same firm. Yeah, that's allowed. As unfair as it may feel when you're provisional going up against somebody that's done thousands of deals, well, you've got your BIC on your side. That's what's the levels of playing field for you. You're up against that pro that has done this a million times. Maybe he might even be arrogant about it and says to you, how many years have you been doing this? I hate that question. And that's what Margie has a great answer for. I think, was that one you had an answer for? My answer for that is long enough to know better than to answer that question. Ha, 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 ha. And you just laugh it off and move on because it's irrelevant. But by the way, you probably know the laws and rules better than they do. Anyway, provisional broker and non-provisional in the same firm is allowed because the provisional broker has the BIC they can lean on. It's required. That BIC has to do it, has to be there for you. Provisional broker and provisional broker in the same firm. Now, this one might have been tempting because some people might think, well, okay, wait, I'm a provisional and she's a provisional and the BIC is the same BIC for both of us. And how is it fair that the same BIC is helping me and counseling me and I'm helping the buyer, but is also helping that provisional as they're helping the seller? Well, that's fair. It's a fair question, but the BIC is not going to give each other secrets away. They're going to counsel both parties individually. Their job is to make sure that it is done correctly. So B is allowed. B is allowed. Provisional against provisional, even though you're getting counsel from the same BIC, still allowed. Skip to D because you know that's the other one that's not the right answer. Non-provisional broker and broker in the same firm. Well, that's nonsense because that's the same thing. Non-provisional broker is the same thing as a broker. They will tell you if it's not a non-provisional broker because they'll call them a provisional broker. But when you're fatigued after hour 3, you're going to read non-provisional and you're going to think provisional. Be careful about mental fatigue and the words kind of mixing up on you. The one that is not allowed in designated dual agency is C. You all got it. The broker in charge of that firm cannot be on the other side of the negotiating fence from their own provisional broker because that provisional needs to be able to lean on that BIC, their BIC, and help them get guided through the transaction. And it's impossible to serve two masters. It's impossible for that BIC to help that provisional as they assist the buyer, for instance, while the BIC is helping the seller that buyer wants to buy from. That is not allowed. Now, a nuance here. It is not allowed to have designated dual agency between a provisional broker and their own BIC. But is it allowed for a provisional broker alongside their own BIC to both be true dual agents between the buyer and the seller? Is that allowed? Because that's different. That one is not the same thing. Good answers here. Yeah, that's okay. I get people on that in CE all the time because you're so conditioned to think provisional against BIC not allowed. But it's provisional against BIC not allowed in designated dual agency. Provisional against BIC is not what's happening when it's true dual agency. It's not against anybody. You're both true dual agents together, you and everyone in the firm, by the way. If your firm is a true dual agent, there's no designated agency happening anywhere, then everybody in that firm is a true dual agent. And all of them are not allowed to have loyalty to the parties. All of them are forbidden from telling buyer lowest the seller might take or telling seller most buyer might pay. And all of them are not allowed to give an advantage to either side. Good? You're just already a step ahead of everyone else who's been in the business a while, who goes through CE, because you get that. Last one, the working with real estate agents disclosure. Which of the following is true? Good job. Working with real estate agents disclosure. Again, when you start looking through sample questions, whether it's the ones that we give you or the ones that you might get elsewhere, like the place that we're going to give you the final exam through, they provide a test bank access for money if you want to pay the money to have access to their 1,200 questions, by the way, between the national and the state, or you can buy a national but not the state or vice versa. Read the question and get everything you can out of it, right? So let's look at why the first answer is not correct. Must be given to all consumers in real estate transactions. What's wrong with that one? There's no mention of whether a broker's involved, right? There are transactions in which it's an unrepresented seller selling to an unrepresented buyer. There's no broker in the transaction at all. Therefore, you don't need to give them the disclosure about how to work with a real estate agent. That's one that they like to give you, that they like to throw at you. If there's no agent involved, this disclosure is not required because it's in the name, working with real estate agents disclosure. When it said must be given, so you're thinking, oh, who's giving it? The agent's giving it. So there's an agent involved. You read too much into it, right? Must be given to consumers no later than initial contact with a broker. Okay, well, now a broker's involved, but what kind of contact are we talking? Not initial. That's hello, my name is Neil. It's first substantial, right? no later than for substantial contact. That would make it a correct answer. That's what you're doing here. What would make these wrong answers correct? And then creates an agency relationship between a broker and a consumer. Well, we know that's not right because that's in the name as well. It's a working with agents disclosure, not a contract or agreement. It's nothing that hires you. You still have to do that paperwork next. You do the working with agents disclosure to explain how it all works. Then you have the conversation, decide how you're going to move forward, and then you pull out the appropriate document to nail that down. Listing agreement, exclusive buyer agency agreement, whatever it may be. So it's D, proof that a broker has disclosed and explained agency options to a consumer. It's proof, and we say this to kind of soften the blow to them all the time. It's actually kind of written in it automatically because you just met them. You're trying to build trust and rapport, and now you're asking them to sign something. So it's useful to say, look, guys, this is not my requirement. This is the North Carolina Real Estate Commission, which is in place to protect you, the consumer. Therefore, they want me to have proof that I explained and had this conversation with you. Here's how it works. Here's how agency works. Currently, I'm representing the seller. You have an option to hire me. If we decide to work together, I can be your buyer agent. And if you decide to buy this very house, which I have listed, I can be what's called a dual agent. Blah, 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 on and on, right? And it's just proof for me to have in my file because the Real Estate Commission could come down here and audit my files and see if I'm doing it right. I need to have proof in writing that I explained this, had this conversation with you. This does not hire me. The form even says all that itself, so you're pointing it out. Okay, back to Chapter 9. The essential elements in a contract. The elements which make it a valid contract. Mutual assent. It's basically saying, yep, this party is offering and this party is accepting that offer. And as long as these other three things are in place, this is a legal, valid contract. Mutual assent just means offer and acceptance of that offer. Consideration. We're going to get into these individually in a second. What is consideration? How considerate. Oh, you held the door open for me. How considerate. You've got consideration. You're polite. No, that's not it. Yeah, the money. The items of value. Something of value. It's not necessarily money. It's money and cars and blah, blah, blah. It could be, but it's usually money. Consideration, some version of consideration. However, not every part of money, not every piece of money involved in a transaction is legally called consideration. The earnest money and the due diligence money is not considered consideration. Those are in place to show seriousness. And they are also in place to give some sort of enforceability. If the buyer breaches on the contract, the earnest money that's in the deal and the due diligence money that's in the deal are in place to give the seller some recourse, to give them some liquidated damages because that buyer's walking and not fulfilling the promises spelled out in the contract. So those two things are not the consideration. The consideration is what you're bringing to the closing table. The suitcase full of money. Just kidding. They don't like that. Don't bring suitcases full of money. Needs to be documented. But it's that. It's the down payment. It's the money that the buyer needs to bring. It's the money that the buyer's borrowing from the lender. All that combined at closing that is paying for the property is the consideration. Competent parties and lawful objective. We'll get to those in just a second. This mutual assent thing, one party is offering terms, sending to the other party for the answer, and that other party is accepting them. Both parties have agreed. This is what we're going to do, and this is how we are going to do it. They have a meeting of the minds. This phrase, meeting of the minds, is what you're looking for. Has that been accomplished? If you had a dispute, the judge would be looking for the meeting of the minds. Do we have a moment at which we can identify a meeting of the minds? There have been condo projects, new construction, which took orders online with a website. And because of the way they set it up and allowed for like electronic signing, as well as uploading, wiring wiring money. Wow. Wiring the money and electronic signing. And there have been cases where, because they made it all so streamlined and automatic like that, people ended up being obligated and under contract when they really didn't think they were, because they did all the things. Had mutual assent because of the way it was worded on the site. So you got to be careful about stuff. You have to put some disclosures in sometimes if you don't want it to be quite that easy. In our world, when we do stuff, it's harder for that to happen. But one party's making an offer that the other party accepts. They've come to a meeting of the minds. Now, there are some things in place in this contract that still have to be fulfilled. And at some point, the parties could back out and get out of it for various reasons. We'll talk about that. If the party who makes the offer does so, and then the one who receives the offer, who is called the receiver, the offeree, right? If they make any change to that initial offer, it is considered a rejection and a counter offer. What's a change? Tell me some examples of changes. What could you do to make a counter offer, change the original offer? What kinds of things might you change? Certainly. Price change, some sort of an allowance, repair allowance, fixture change. Okay. Yeah. It could even be as simple as a date. You could say in your offer, I will have a settlement meeting on or before October 30th. But then the seller says, okay, I like your price. I like everything about this offer, except the 30th is no good for me. It's my hamster's birthday. We don't do anything on that day. We're going to close on the 29th, but not the 30th. But everything else is the same. Everything else I'm fine with. If that buyer says, well, I don't like that. The 29th is my hamster's birthday, and that's why I made it the 30th. Therefore, I'm out of here. I'm gone. Even if the seller has the original offer in their hand and they find out the buyer's walking over this one day and they hurry up and sign it and they say, oh, nope, too late. I signed it. Doesn't matter. Their counter killed it. They communicated their counter of that 1 day difference and it killed the initial offer. There's no going back to that initial offer, period, unless the buyer allows them to. The buyer would have to reinstate it and say, yeah, okay, we'll go back to it. But otherwise, seller just cost themselves a sale because of 1 day. That's why as brokers, we need to be really careful to give advice to our sellers. Okay, you want me to counter with this? Is that a big enough deal to risk them walking over it? Because they could. Any change is a counter offer. And more specifically, any change is a rejection and a counter offer. You kill it with any change. And you got to wait for them to agree to go back to the original if that's what you want to do, if they threaten to walk away or if they do walk away. Right? So a counteroffer is what? Tell me in the chat. What's a counteroffer? First and foremost, good job. A rejection. And then it's a counter proposal. Yep. By the way, whether you're talking about an offer itself or the counter offer, when you're going back and forth, let's say the seller says, yeah, that 1 day makes a big deal difference. I just can't do the 30th. It's got to be the 29th. So that's my counter. And then maybe the buyer's thinking about it. And the seller's getting nervous because it's been 3 days. The buyer still hasn't said yes, no, or maybe nothing. And the seller just gets super nervous and they're like, well, currently I'm still having showings. I've got some really interested people that just came through today who maybe even one of them brought an offer that's better than that original one. They're waiting on the counter offer to be accepted. That seller could say, okay, I'm done with that counteroffer, cancel it. They could tell their agent, rescind it, tell them immediately, I'm out, I'm backing out, I'm taking it back, no counter, off the table. As long as they do that before it's accepted, they're good. And that happens a lot too. You get a better offer. That's why you want to hurry up and button things up fast, right? Because at any minute, another offer could come along that could change everything, because now the person is tempted by that. So a counter or an offer can be withdrawn prior to acceptance, prior to the point at which that other party signs and communicates that they signed. Could be withdrawn. Counter is a rejection and a creation of a new one. Communication to the agent is communication to the agent's principal. What does that mean? This element of communication is crucial. This is what the average person on the street would get wrong if you were to have a clipboard and a microphone and go out there and just ask people, do you know anything about contracts? They wouldn't get this right. They would think, yeah, once you sign it, you're locked in. Nope. Once you sign it and communicate that you accepted it, then you're locked in. The communication is what is going to be looked at in a dispute. Was it communicated? So, to whom are you communicating? You've got a buyer agent. Maybe we do it this way. We have a buyer agent. Where's my cable go? Sorry. Okay, here we go. We have our buyer. This is the imaginary fence between the parties, right? There's me watching. There's the seller. Our little buyer agent here. Oops. Let's get a different pen. The buyer agent right here makes an offer or prepares an offer which the buyer signs, and they send it on over to the listing agent. The listing agent shares it with the seller. The seller says, one day, I like a different closing day, please. Maybe even a little more money. They write a new offer, also known as a counter offer. And they send that back over, right? The making of the counter offer or the accepting of the original one doesn't matter until it's been communicated back over. In the meantime, we've got this counter offer back over here with this buyer, and they're thinking about it for a few days. And in the meantime, new offer comes in, new buyer's offer. That seller's like, oh, wow, that's way better than that other one. And they tell their listing agent, hey, you need to cancel that counter that we sent over ASAP because I want to start talking to this person. The problem with leaving this alone and not canceling it while still talking to the new person, and maybe they say, could I counter the new one and then wait and see what happens with this one? Well, only if you can magically make another house just like this one appear in the same location, the same everything. Have two houses to sell, one to each, in case that both offer, in case they both accept, right? That could be the problem. That is the problem. So they would want to cancel that counter in order to pursue the new one. That new one better be good enough to give up and throw this fish back in. You with me? It's all about the communication. So if that listing agent tells the agent helping the buyer, oh, there he goes again with those word tricks. We'll talk about our word tricks after break. I'm going to make you wait for it. Yep. Okay. Let's come back at 11. Okay. No, I'm not. Welcome back. Oh, yeah. Okay. So communication. That's our issue. We've got a buyer making an offer through their buyer agent over to the seller. The listing agent gets it. Listing agent talks to the seller about it, says, here it is. Seller says, you know what? I accept. I'm just no changes. Going to, got this little offer here. I'm going to sign it, and I've signed it. Are we under contract? Seller has signed it. Listing agent gave it to the seller. Seller didn't make any changes, no counter. Seller signed it. Are we under contract? Here's a question that might help. Do we have this? Do we have the necessary communication? Okay, how about this? Seller signs it and tells the listing agent, I signed it. Seller says, yep, I signed it. Is that the kind of communication that we need? Still no. We don't yet have the communication necessary for this to become a contract. Seller signed it. That's not communication. They told the listing agent they signed it. That is communication, but not the communication, because what counts that makes this a contract is the listing agent telling the buyer side. You with me? That's the communication that matters. But if you'll notice, I didn't say buyer agent, I said buyer side. Because there's a difference. There's a little nuance there too. In this case, we have a buyer agent we already acknowledged. There is a buyer agent, meaning the buyer has hired them with a buyer agency agreement. They are their buyer's agent. The listing agent told that buyer agent that the seller accepted. Since it's a buyer's agent, then yes, we're under contract. But what if it wasn't a buyer's agent? What if instead of this person that's helping the buyer being a buyer agent, they were instead a sub-agent to the seller, meaning that buyer refused to sign a buyer agency agreement. And if that agent kept working with them, they would have to work with them as a sub-agent to the seller by default. Remember that part? In this case, the listing agent gives the offer to the seller signs it, they tell the agent they signed it, the agent tells the sub-agent, the agent tells the listing agent tells the agent who's helping the buyer, communicates to them that the offer was signed. But this sub-agent does not tell the buyer. Maybe the buyer's on vacation. They can't be reached. We do not have a contract. We're not under contract because this is a sub-agent in this case. And what is going to be required to make this a contract is for that sub-agent to finally reach the buyer and tell them and communicate with them. So when it's a sub-agent helping the buyer, the communication back across the fence has to go all the way to the buyer. It's not good enough that it goes to the agent. It's only good enough that you tell the agent when that person is a buyer's agent specifically. So let me rewrite it. Got a bunch of scribble scrabble. I know it's tough. We have two possibilities of representation here. That buyer could be working with a buyer's agent, which is smarter because they're looking out for them. So they could have their own buyer agent, or the agent helping them could be just a sub-agent to the seller. Are we okay with that idea? And the difference is, do you actually have a buyer agency agreement signed? in place between these parties. That's what makes you a buyer agent, is if you've got a buyer agency agreement signed by them. If they won't sign a buyer agency agreement, then by default, you're a sub-agent to seller. You're still helping the buyer, but you're telling them, don't tell me anything you don't want the seller to know, because I'm not your buyer's agent. I can still help you. Side note, remember when we looked at the bottom of the MLS sheet? Sometimes if you're a sub-agent to seller, you may not want to be because you're not making anything. Remember at the bottom of the MLS sheet, it showed commission percentage to buyer agent, 3%. But if it's to sub-agent, it's 0%. That's an option the seller decides. You, the listing agent, and the seller decide if you're going to pay an agent who is not a buyer agent helping that buyer, but instead is only a sub-agent to seller helping that buyer. So there's two possibilities here, this one and this one. The seller has signed the offer. The listing agent is communicating back across the fence. If the listing agent is communicating back and it's a buyer agent that they're talking to, then we have a contract. We are under contract, yes. But if instead it's not a buyer agent, but a sub-agent to seller that they're dealing with, who's helping that buyer, then we do not have a contract, because that listing agent has communicated to them. That's not good enough. That is not enough communication. That sub-agent would then in turn need to get in touch with that buyer. Because see, when it's this one, communicating to the buyer agent, maybe a scenario would help. You've got a buyer who's going on a hunting trip. He's going to be in the mountains, no cell reception. He leaves on Friday, but not before he writes an offer with his buyer's agent. And he says to them, I'm going to be out of pocket for 2 days. If they accept, let me know. And so they go ahead and present the offer. Listing agent presents it to seller. Seller accepts it sight unseen like Saturday. And the listing agent finds out from the seller, yep, I'm good with that. We'll take it. And so the listing agent calls the buyer agent or emails or both and says, we have a deal. We're under contract. And because it's a buyer's agent, that's good enough. You are under contract. The guy's in the mountains. He doesn't know yet. He won't know for 2 more days when he gets back into cell coverage. But what if he comes back on Monday and he says, before the buyer agent can tell him anything, he says to him, you know what? Forget it. I went to the mountains. I realized I don't want to live in a traditional house in a neighborhood. I'm going to build a cabin in the woods and live off the land. I'm changing my whole lifestyle. Forget that deal. I'm out. I'm rescinding. Doesn't matter, because the buyer agent had that relationship. There's a buyer agent that he's hired. Therefore, when that listing agent told the buyer agent it was a deal and communicated the acceptance, it became under contract. And he might be angry, and he's going to have to figure out some other way to get out of it, but he's under contract because it was a buyer's agent that got communicated to. Let's change the story a little bit. Friday, he goes on the hunting trip, gives the offer, says, let me know what happens when I get back. You can't reach me until then. It's not a buyer agent, though. He's being helped by a sub-agent to seller. It's Saturday. Seller accepts. Listing agent finds out they accepted, and they tell the sub-agent, yep, good news, we're under contract. And the sub-agent says, no, we're not. I want to be, but my buyer, I can't reach them. I can't reach them and tell them that your seller accepted yet. Therefore, we're not under contract until I can tell them. So buyer comes back on Monday, has a revelation, says, yeah, I went in the woods. I don't want to buy a traditional house, going to live in the woods. And as long as he told the sub-agent that before the sub-agent told him that the seller agreed, then yes, he can go be a hobo in the woods. But if the sub-agent is better and says, okay, buyer, shut up. Before you say anything, you're under contract. That's communication. We're under contract. Now, in real life, there's going to be a lot of anger and people arguing and going to having disputes, but we're just talking about what does it take? Like, according to the rule, the communication to the buyer agent means whether the buyer has heard the news or not, you are under contract. But if that buyer does not have a buyer agent, but instead has a subagent, communication to that agent is not enough. It's only under contract once this subagent actually reaches the buyer and gives them the news. Now you're under contract. Do you get that difference? You can see how the test question could really be confusing, right? Just have to take it step by step and identify that point of communication. That's how the test question is going to be written. They'll give you a whole paragraph and they'll say, at what point in this chain of events did you go under contract? A, B, C, or D? Yes. Well, the seller would talk to their own listing agent, actually. Yeah. Okay. So, yeah. Okay. Yes. Okay. Locked in, under contract. Right. Right. And tell them the news. Then it's under contract. Yeah, the communication would have to be to the buyer from the subagent in order for it to go under contract. Yes, you got it. That's it. That's why this agency stuff matters, because this is real world. This is real world dispute. When people change their mind and want to rescind, it's not as easy as saying I rescind. It's, wait, so who did you communicate to? Are we under contract or not? Here's another little element, point of confusion. With an offer, you could write earnest money, an earnest money check, and also give them a due diligence check, a due diligence fee. Let's say that earnest money is $5,000. And let's say the due diligence money is $20,000, because that was a real thing not too long ago. By the way, due diligence money, not refundable. So the buyer writes an offer. Agent submits it to the listing agent. They do not send them the checks yet. They could, but they haven't. They certainly aren't going to send them the due diligence check yet, because you don't give that over until you're under contract, because that goes straight to the seller. It's written to the seller's name. The seller can spend it immediately. As soon as you go under contract and that seller gets that due diligence check in their hand made out to Joe Blow's seller, they can deposit it, spend it, and there's very little situation where they're ever going to have to give it back. It would only be if they breached, possibly. But for the most part, it's never going to be a repair situation that could come up, even if the house is about to fall down and the buyer says, well, I'm not buying it because I found out it's going to fall down. Okay, don't buy it, but you're still out the $20,000 non-refundable due diligence money. Doesn't matter how bad shape it's in. That's why you better be comfortable making that offer in the condition that it's in, because it's you're at risk of losing that money. Or the property is listed for $450,000. You make an offer for $470,000 because you're trying to beat out all these other offers, and you win. They take your offer for $470,000 because of eagerness. That's why you went that high over asking price. But the appraiser disagrees. The appraiser comes out, can't find justification for $470,000. There's no other houses that have sold near that price, similar to this. The appraisal comes in at $440,000. Does that buyer have to buy it? No. They could say, well, I'm not paying $470,000 for a house that's only worth $440,000. I'm out of here. Okay, bye. I'll enjoy keeping your $20,000 because it's non-refundable, even if it doesn't appraise. That's why it was so stressful, still is, but certainly these last few years, buyers had to put out so much money to win at the mercy and at the risk of these inspection and appraisal issues, causing them to want to walk away, but they have to decide, am I willing to walk away from that much? that make sense? Okay. I'm going to get a lot more into that. Communication to an agent is communication to the principal of that agent. What about termination? As long as it's before the person accepts, you can withdraw or revoke an offer or counteroffer. As long as you do it, doesn't matter that it's out there. It doesn't even matter if you, sometimes a buyer will say to a seller, here, I'm going to make you an offer, but I need to hear back by noon tomorrow or it's off the table. They put an expiration on their offer because they want to move on with life. They don't want some seller to hold them hostage and think about it for a week while they let their plan B house or plan C house, their other backup houses, go away. So a buyer might make an offer with an expiration date attached. But even if they put an expiration date tomorrow at noon, this is no longer an offer. Maybe tonight at 7, they keep looking. That's what they want to do, by the way. When they submit offers with expirations, they say, Neil, can we keep looking just in case they don't accept it? And you're like, well, this might be a waste of time, but yeah, okay. Right. So we go out tonight, we look at a few more, and they get really excited about one of those. And they're like, you know what? I know we gave them till tomorrow at noon, but I'm out. I rescind. And they can. They're allowed to rescind, even if it's before the deadline that they told the other party. Doesn't matter. The deadline is irrelevant. You can rescind anytime before when? How long do you have to withdraw an offer or rescind an offer or revoke an offer? Anytime up until before acceptance. Yeah. An offer could also go away because it's rejected. And it could be rejected in one of two scenarios. A straight out, I reject with no counter, or a counteroffer. And any kind of counter is a rejection and a counter proposal. So both of those scenarios constitute a rejection. Consideration, we talked about, is the item of value. Whatever you're exchanging in exchange for the deed to the property. Usually money. Anything bargained and exchanged for. Could be a herd of fainting goats. Don't you love the fainting goats? Anybody seen the fainting goats? You know, you scare them and they just fall over. That's adorable. There's some people that I wish had that characteristic. Money and fainting goats and a car and a couple guitars. Could be. Usually not. It's usually just straight up money and borrowed money. It's all money to the seller. It's kind of funny sometimes when somebody says, I'm a cash buyer, you should bow down before me. Well, it's all cash to the seller as long as the loan is good, right? So the question is not, is it a cash deal? The question is, how good is your qualifying? How good is your pre-approval letter? Because I'm not getting a loan note from the lender. The seller is getting the cash from the lender, the check from the lender, and the whatever the balance left over owed from the buyer. It's the buyer that gets to inherit this, got to repay this thing over time over the next 30 years, right? To the seller, I'll take a qualified borrower, or better yet, unapproved borrower. Approved means you've done more research, more homework, maybe looked at a credit report. Pre-approval letter is better than a pre-qualification letter because of that. Pre-qualification just means, yeah, hey, buyer, how much do you make? Yeah, you should be fine. I'll give you a pre-qualification, but then you find out they lied to you, right? So look for pre-approval letters, not pre-qualification letters. Some lenders call them different things. But consideration is this stuff you're bringing at closing in exchange for the deed. Consideration is not those other two things down here. This $5,000 earnest money, by the way, it could be $1, and it also could be $0. Both of these are negotiable. Both of these could be $0. If you could find a seller willing to go along with that, good luck. Earnest money and due diligence money can both be nothing. They are both negotiable. And neither of them are considered consideration. The consideration is what you're bringing to closing. These two things you're bringing along with the initial offer or very soon after the offer is accepted. There it is. Earnest money is not required. It's going to be dictated by the market. How likely is that seller going to be to take your offer when they have 10 more offers that are putting in earnest money? probably you're not going to come out too well, because they're going to take the one that's putting earnest money in the deal. But what is earnest money? It's not going to the seller, by the way. It is a check written out to whoever's holding it. And who's holding it? It's going to be either one of the firms, either the listing firm or the buying side firm, or it's going to be the settlement attorney. Because when you create a firm, you do not have to have a trust account. You don't have to set up a trust account. It's not required, because you might be a firm like me and I don't hold earnest money. I don't want to deal with the trust account. The commission says if you hold other people's money like earnest money, you've got to hold it in a trust account. You can't hold it in your own operating account because it's other people's money. Well, I don't want to do it. So I don't have a trust account. Therefore, when I make offers on behalf of my buyers, I tell the listing agent, hey, I can't hold the earnest money. I don't have a trust account. You're going to have to hold it. And sometimes they say to me, well, we don't have a trust account either. And so we say, let's just let the attorney hold it. It's some entity in the transaction who's got a trust account that can park this money. And that is to whom the money is made. So the earnest money will be made payable to whoever's the account where it's going to live for the next few days, few weeks until we go to closing. And earnest money is not, it is refundable. Earnest money could be refunded. That's why we call it a deposit. Deposits could be refunded, like a tenant security deposit when you rent. You might get that back if the carpet's in decent shape and other things, right? Deposits could be refunded. Earnest money might be refunded, maybe not though. What dictates whether an earnest money deposit gets refunded? If the deal falls apart, if the buyer backs out, for instance, it's the time frame. You've got this. The offer is made here on this timeline. That's where the offer is made. Here's our closing day. It's when closing's recorded. People start getting money and keys. Everybody's happy. The offer is made, and with that offer, the offeror is going to say, look, I want some amount of time to make sure that this property is what you're holding it out to be. I want to have inspections and an appraisal and maybe a survey, and I want some time to do that. Therefore, give me this much time, and we'll call this the due diligence deadline. This date, we're going to say it's October 15th, and in our standard offer to purchase, it's already built in that it's automatically always 5 p.m. on the date put in the blank. So as of 5 p.m. on October 15th, if this buyer chooses to move forward, yes, everything still looks good. I'm going to keep going and get all the way to closing. Once we're beyond this 5 p.m. on October 15th, now the earnest money deposit, if that buyer decides to back out in this time frame, they're going to lose the earnest money. They're not getting that back. It's written up that way. If instead, though, they decide to back out in this time frame, during the due diligence period, then they could get that earnest money back. Whoever's holding it is going to cash it or cut a check and send it back to that buyer because the buyer chose to back out of the deal. So what happens to the due diligence money, by the way? Remember, they went under contract, and that due diligence fee, it's a fee, meaning non-refundable, whatever that is, they had to turn that over to the seller, made out to the seller. Seller could immediately spend it, cash it. And they had to do that as soon as it went under contract. So if they decide to back out like here, it's before the due diligence deadline. They're not getting this back because that's non-refundable. They're out of that period. But they probably are going to be able to get that earnest money back legally. The reason I say these cushy words like possibly, probably, is because The thing that determines whether they get this earnest money back legally is the date, as long as it's before the due diligence deadline, 5 p.m. sharp, by the way, not 5:01. But if the seller, is a little mad that the buyer asked for some things to be fixed, that the buyer's even backing out, the seller could be mad the buyer's backing out because that puts a kink in their plans. And they say, well, forget them. I'm mad at them. I'm not signing the release of earnest money, letting them get their earnest money back. I'm not going to sign the release. And whoever's holding the earnest money, whether it's one of the firms or the closing attorney, can't give it back unless they have something in writing, a signed release saying, yep, seller's okay with it, buyer's okay with it, we're going to let the buyer get it back. Even though it's written in the contract, offer to purchase 2T, clearly states buyer should be entitled to get the earnest money back as long as they withdraw or cancel the contract before the due diligence deadline, 5 p.m. Still, if I'm the one holding the earnest money in my trust account, if I had one, I can't touch it, even though I like the buyer better than that jerk seller. Doesn't matter. I can't give it to the buyer just because I know they should have it, because even if it's in the contract, I've got to wait till I have a document with both signatures on it because they get mad at each other. Yes. Mm-hmm. Mm-hmm. The due diligence money? Yes. Yes, it's hard and fast, non-refundable. Couple things there, though. The not disclosed thing is a non-issue because the seller doesn't have to disclose. Remember? They can fill out that disclosure form that says, do I know of a problem? Check the box for yes or no. Or they could say no representation. I'm not telling. They could check that for the whole disclosure. Now it gets a little messier if the broker knows and failed to disclose. They would still lose the due diligence money in the transaction. Then they'd probably go after the fact and pursue the broker, complain to the real estate commission, and handle all that stuff later. But for the sake of this transaction, that non-refundable due diligence fee is pretty much locked in, non-refundable. Almost no reason that the buyer's getting that back. Yeah, but you make a good point. Let's see. Yeah, Jennifer, due diligence is pretty much never refundable. The only time the buyer could get the due diligence back is if the seller breached. Now, if the seller were to breach and not live up to their promise, just change their mind about selling, it's a lot harder for a seller to change their mind about selling than it is for a buyer to change their mind about buying. You with me? It's harder for a seller to back out than it is a buyer, sort of. So what is the remedy available to the buyer if it's the seller who breaches? Well, now the buyer can sue for that thing called specific performance. They can sue the seller because that's a unique property in a unique place. There's only one property like that in that one piece of dirt. Now, we've all been in cookie cutter neighborhoods and we're like, yeah, kind of. One is as good as another, but theoretically, legally, properties are unique. They could also, that buyer could sue the seller and get their due diligence money back, their earnest money back, their inspection fees that they've spent, the survey that they paid for, the appraisal money that they spent. It could be thousands and thousands. All the money they spent in good faith working toward closing on this thing, and then the seller up and just changes their mind about selling. That seller, one time I had a seller and they said, oh, well, yeah, we'll go ahead and accept it, and we might decide later if we don't want to do this. And I'm like, okay, let me explain how this works now, because it's not that easy. Please don't do that. And then I had that other seller I've already told you about. who it took so long to close because she had a tenant who wouldn't leave. And 9 months later, she realizes, wow, tenant's finally gone. We can go through to closing, but I'm kind of upset because in the meantime, my property's worth more. Because a couple of years ago, appreciation was happening so fast, still kind of is. She realized that 220 was not an accurate and fair number. She also, by the way, had spent about $15,000 on some roof and HVAC repairs, replacements. So she wanted more money now that we were free of the tenant issue. And I said, well, we have a contract. Well, yeah, if they're decent people, and I'm like, it's not about being decent. It's about what's in the contract. Well, do you work for me or them? I'm here for you. That's why I'm trying to explain this to you, because I don't want you to get sued for specific performance. By the way, let me let you talk to an attorney because they need to explain all that to you. I'm not an attorney. In real life, you're not going to talk to them too long about this. You'll tell them the possibility, then let them get some legal advice before they do something to harm themselves. Remember that part? Client might try to do something to harm themselves, and it is our fiduciary responsibility to counsel them and keep them from doing so. So I said, here's an attorney's name and number. She ended up going through with it all. I think she realized that her problems weren't with that buyer, but in fact with other things in life. Sure, please. That's a good question. Great question. So let's say that they did breach. Seller breached. First of all, I could go after the seller because I did what I was supposed to do, and now I want you to pay me, seller. You breached, you backed out, but you owe me commission because I brought you a ready, willing, and able buyer. Now, I may not want to sue my seller. I may not want to do that, but I might be forced to. Because like you said, maybe that buyer agent is also mad. They come to me and say, Neil, you said you'd pay me part of your commission. Therefore, I'm suing you for that part of my part of the commission. And therefore, in turn, I need to go after the seller to get it so that I can give it to the buyer who's demanding it from me. See that? It could get messy. Yeah. I've never had that happen, knocking on wood, right? But that's how those chain of events could happen. The dominoes and people, usually when things fall apart, people start issuing threats, but then they're like, yeah, but it's going to take some money to attorneys to pull all this off. Do I really want to take the time and spend the money for what? Especially when it's an earnest money dispute. If it's reasonable, kind of a normal earnest money amount, even if it's a couple $1,000s, by the time you have an attorney pursue it and get awarded it, you probably spent a couple $1,000s for the principle of the thing, and you're spending that money you had them fight for you to get to the person who fought for you, right? So people usually drop things because of that issue. But when you're talking about due diligence money of $50,000, that might change the ball game a little bit. I have not heard directly, but I'm sure there are some disputes of people who back out, and the money is that high. Those stakes are that high. Buyers making offers using due diligence money that high, they're kind of already mentally prepared for the ins and outs, and they're like, I'm acknowledging that I'm pretty much telling the seller I'll take it as it is. They might still ask the seller to fix stuff, but what's the seller going to probably say? You gave me $50,000 non-refundable due diligence money, and now you're asking me to fix a loose doorknob. That's a no. But some sellers have sort of a pride of ownership, and they're like, yeah, okay, I got 50 grand. It's decent. Yeah, I'll spend 500 or 1,000. Some sellers are just like that, but others are like, nope, go ahead, walk. I dare you. Let me get another buyer in here to give me another $50,000. There are some that went that way, right? They're kind of in the business of collecting due diligence checks rather than actually caring if the house sells. It got a little out of control. I don't know that we ever foresaw this as a possibility when this concept of due diligence fee came about. This has not been the case since I've been in the business. It was not around in 1996. I don't even remember when we got due diligence money. Do you remember, Margie? When was it that due diligence fees became a thing in our market? Everything feels new to me because I've been in it so long. It's like, was it about 10? Yeah, That sounds right. Yep. So before due diligence fee, no, it's fine. Yeah. Yeah, but before due diligence was a thing here, the only money, skin in the game, so to speak, that the buyer had was the earnest money. So the seller did not have anything in hand. And therefore, what would happen, and I think is part of the reason that they decided to do this, a buyer who had a good buddy lender who wanted to maybe help them out, week of closing, that buyer might decide not to buy it, but not because they didn't qualify, but because they just didn't want to buy it anymore. And they could have gotten a bad lender to say, yeah, I'll write you a letter saying you don't qualify. Some stuff like that happened so that they could get their earnest money back and move on with life. So the seller was out. The seller would be like, well, I was just out off the market, missing potential buyers that would go through with it for 30 days, 60 days. And now you're backing out and I don't even get earnest money for my trouble. Then they kind of rewrote things, included due diligence period instead of what used to be called an inspection period, but it was the same idea. During the due diligence period, we're going to do inspections and do anything that the buyer might need to know to proceed with the transaction. That's what you're trying to figure out here. The buyer's trying to figure out, do I want to go through with it? Because I'm going to be out this. I already am. It's not in my account anymore. I had to turn it over. Am I going to also be out this? And am I willing to go past this date so that now this is also going away if I do back out during this period of time? It made people get real serious. It eliminated sort of casual buyers, right? Here's another question. Can a buyer make more than one offer? Can a buyer offer on more than one house? Can a buyer make more than one offer, like on multiple houses? They like to, and they go ahead and make offers on both. What happens if both of those sellers accept the initial offer? What's the risk to that buyer? Are they going to have to close on both of those houses, be able to afford both of those houses? Ashley makes a good point. Whoever accepts first, but the problem with that might be, what if they both accept and communicate pretty much at the same time? Because you're not just waiting by the phone. You could receive the communication because you were out of pocket, and then you checked your email, and then boom, there's them both at the same time. So it's not a race to the courthouse kind of a thing. It's all about that due diligence money, Shane. There you go. So yeah, a buyer could make offers on 4 houses. And if the due diligence money that they put down with each of these offers is something they can afford to lose, and as long as they can afford to lose 3 out of the 4, let's say they do $1,000 due diligence on each one back when that was possible. Well, all 4 of them accept. Congratulations. Now you get to pick. They can only afford one, but all 4 of them accept. As long as they can still lose the 3 due diligence checks to those ones they chose not to take, then yeah, you can make as many offers as you can afford the due diligence fees, right? You're not obligated to go all the way to closing. You have this amount of time that you paid this amount of money for to think about it and back out if you want to. That all worked great till 3 years ago when this became this. Now, typical due diligence fees are 5, 10, 20, 50. Average due diligence went from 500 to 1,000 to 5,000 to 10,000, with frequent exceptions for 20,000, 100,000. And I think I already told you, in a CE class, somebody said they had a deal where it was a $400,000 due diligence fee on a $400,000 priced house. They basically paid for the house at under contract point. And then just 30 days from now, just give me the keys, right? No chance that seller is probably going to fix something. Or at least they might fix the piddly stuff. If I were that seller, I'd probably fix things up to $1,000 or $2,000 just to be done with it. But some sellers might not do that, right? It's all real world stuff. So earnest money is an expression of good faith. It's a promise. It's not a promise. It's a, yeah, I am proving to you that I am serious buyer, earnest buyer. With this, it also used to be called good faith money for that reason. The capacity of the parties need to be 18, sane, and sober. You can still have a contract and have a successful closing if somebody is not 18, sane, or sober. But at any point, they could back out, and there's nothing you could do about it. If you're 18, sane, and sober, you're the one who's not got that voidability, so to speak. To them, they have voidability because it's a voidable contract because they're either not 18, not sane, or not sober when they signed it. It needs to be for a lawful purpose. If you're deciding to buy the meth house in the middle of the marijuana field and then they back out of the deal for you and you're mad, so you sue them and go to court and you say, hey, Judge Judy, they owe me money because they backed out. I was going to buy their meth house in the middle of the marijuana field, right? It needs to be for a lawful purpose. Contract for an illegal purpose or maybe discrimination based on fair housing is unenforceable in court. Illegal purpose, not going to work. So a seller who does not want to sell to a minor could terminate the contract, true or false? Of-age seller does not want to sell to a minor that they are under contract with. Could that seller terminate the contract without any ramifications? No, they could not. The minor could because it is voidable. And if it said seller who does not want to sell to a mentally impaired person could terminate the contract, do we know enough information to make an answer to that, to give an answer to that? Seller who does not want to sell to a mentally impaired person could terminate the contract, true or false? I would say, tell me more. Is that mentally impaired person, were they legally declared? Therefore, it's now a void contract. Therefore, now either side could back out. Oh. Or was that mentally impaired person not legally declared? It's just a medical assessment. Therefore, it is voidable, not void. Therefore, only the mentally unstable side could back out, but not the other side. The difference between void and voidable hinges on this legally declared component, right? When should things be delivered? All counters, all offers need to be delivered ASAP. We write them up. We need to deliver them. We as the brokers need to deliver them as soon as possible, but not later than 3 calendar days. Testable question. So the test question might say this: all offers and counteroffers must be delivered when? Answer choice A, as soon as possible. Answer choice B, not later than 3 days. C, not later than 10 days or not later than 20 days. Best choice out of those 4, the ASAP, answer A. What if the answer choices are this? A, no later than 3 days. B, no later than 5, 10, 15. Best choice out of that group, 3 days, because they didn't give you an option for ASAP. You with me? So the rule is as soon as possible, but not later than 3 days. Ideally, immediately. Drop dead no later than 3 calendar days after receipt. So the magic word about this is get it over, get it to them, deliver ASAP. That is your prime objective. When you're a broker, yeah, okay, running a Facebook ad, writing a post, making a flyer, delivering a lockbox, all the things that we do. But if you have a client who needs you to deliver an offer, all of those things wait. This happens now. And sometimes, kids play, ball game, family time. Now you got a business/family decision to make. Offers need to be delivered ASAP, right? And responses to offers too, by the way. Just good choice, good business practice, because if you just wait for your own personal choice to wait 3 hours because you just need a break, you need some me time, but in the meantime, somebody changed their mind and it harms your client, You have a problem because you put yourself ahead of your client. Need to deliver these things ASAP, get things locked down, signed, under contract. If that is what people want to do, you stop everything and you do that. Then you give in on the other parts of the business. You don't give in on these parts. This is the stuff that you have this for. This is why you're going through this thing right now. This class is to get to that point. That is high priority. So it is true that agency agreements must be in writing. But that is true not because of that thing called statute of frauds that we learned about earlier. It's true because the Real Estate Commission says so. So that could be a testable little nuanced question. Agency contracts must be in writing. Who says? Statute of frauds or commission rule or your mom said so or fee simple absolute? Because the Real Estate Commission made a rule about it. Right? Agency and brokerage agreements are not a part of this statute of, remember what's the statute of frauds say? Remember that one? Thanks, Margie. That's good. Due diligence stuff came around in 2011. That feels right. Wow. We went through 2008, all that stuff without due diligence money. That makes sense. Statute of frauds. Things must be in writing to be enforceable, right? Well, the agency contracts must be in writing because the Real Estate Commission made a rule saying so. Reality of consent. What makes it voidable? Was it fraud? Was it some sort of mistake of fact? There are a couple of terms that you need to know that fall under this, and sometimes people force people or they try to force people to sign things. Here's an example. Elderly seller has a grown child. That child just wants them to go ahead and sell. It's just too inconvenient to drive all the way out there to take care of mom. Rather go ahead and put her in a home maybe that's closer to where we live because we have the family. Therefore, if that grown child says, you know, mom, I really want you to be able to see your grandkids, and we're just not going to be able to make it up here to visit you as much if you just don't go ahead and sell. Right? It's kind of a jerk move, isn't it? Might be true, but if they put some sort of undue influence on that person to sell because of some amount of authority or weight that they have over them, that could make it a voidable contract. Undue influence is exerting your influence over someone. Might be an even worse kind of a scenario than that, though, right? Just threatening somebody with, not really threatening, but influencing them to do something they really don't want to do because of some amount of pressure that you have over them. Duress is different. Duress is a threat of violence or violence itself. You're forcing somebody to sell, for instance, or because you're either going to hurt them or tell them you're going to hurt them. So reality of consent, making it a voidable contract, was it under duress that they signed, or was it through undue influence that they signed? If they could prove those things, then they could have the ability to back out. You can help someone sell their house by using an auction, but you need a little more. You need a broker license, which you're going to get from this endeavor you're engaged in now. But then you're going to also have to get an auctioneer's license if you want to auction property. I don't have one. Never did it. People want to auction things. It might be because they want to sell fast or something. Maybe they're even willing to take a little bit less because it's in the interest of getting it sold a little quicker. And so that's just a whole different mindset. But what you need to know for the test is an auctioneer, real estate auctioneer, has to have a broker license and an auctioneer's license. They're governed by a whole different board over their auctioneer license. That person who's talking really fast at the auction, anybody been to a car auction? Any kind of auction, blah, 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 sold, right? That's called the crier. That's just an employee. They do not need a license. Only one who needs the license is the official auctioneer who's heading the thing up. They need two of them, broker and auctioneer one. because that's the person providing the service for a fee. That's right. Yep. You could think of them as a listing agent who's using an auction as a method of getting it sold, right? Some people use, flyers or open houses or Facebook ads. An auctioneer's using this auction event to get it sold. The crier person doesn't represent anybody. They're just there calling out, taking bids. But they're not facilitating the event. So there it is. The other thing you need to know about auctions, if you'll think about eBay, does anybody use eBay anymore? I'll look on it for some obscure things from time to time, but it's sort of lost its shine, I think. But eBay, with reserve versus no reserve. You could put something up for sale in an auction and say, yeah, let's just see how good I get. I'm confident that the buyers are going to see the value in this and they're going to outbid each other, and it will reach a point that it gets to a price that I'm happy with. That would be an auction without a reserve, putting your faith in the buyers making bids to get up to a point that you're okay with as a seller. But if you don't trust the buyers to bid up to the point that you're happy with as a minimum, you could set a minimum. Okay, y'all bid, but if it doesn't quite reach the $300,000 that I want, then I'm not obligated to sell it to you. So an auction with a reserve would be that. Setting up a minimum price. Price that doesn't get hit, doesn't get met, then you, the seller, are not obligated to sell it. Without a reserve, you're just kind of throwing it out there, seeing what happens, hoping for the best. True or false? An offeror, the one making the offer, can accept a previously rejected offer. True or false? Then we'll have our break. An offeror can accept a previously rejected offer. So buyer makes an offer, seller counters. Buyer says, nope, don't like your counter. Seller says, okay, never mind, let's go back to the original one. Not going to work. The rejected counteroffer is dead. It's rejected. The only way you could go back to the original is if that original offeror says, yeah, okay, I'll resubmit. We'll make it. We'll go back to that. But it's not an automatic. The person who made the counter could never revert back to it just on their own preference without permission of the one who made that original offer. That's why you have to be real careful. And as a broker, counsel them and let them know, look, this is a big deal. Do you really want to counter because you want another $1,000? Maybe you do. Maybe things are that tight. Another 3 days of closing. Any change is a counter, and that lets them walk away, and you cannot revert back to what they initially offered you without them agreeing to that. And they might not agree. They might say, well, I'm out. You said no the first time. You don't get a second chance. Let's have a break. Come back at 12:04. Statute of frauds. Statute of frauds says something must be in writing in order for it to be enforceable. We kind of already alluded to that. The concept of going to court to Judge Judy, and she says, you say that they promised to do such and such, but where is it in writing? You don't have it, then I can't enforce it here in this court of law. So what falls under the statute of frauds? We know that agency agreements do not. Agency agreements must be in writing because the Real Estate Commission made a rule that said they must. But other things must be in writing because of, what are the other things that must be in writing under the statute of frauds? Contracts conveying real property. Real property contracts must be in writing to be enforceable. Otherwise, they're not enforceable. By the way, an oral contract is void. A void contract, it's not enforceable. But you could still end up successfully closing. Remember that part? You could still close on it. Both parties show up. One brings the consideration. The other gives the keys and the deed. You could have a successful closing even though it's a void contract. Void, in this case, meaning an oral, verbal contract, not in writing. But it's not enforceable. If at any point the parties decided, I don't want to do this anymore, and the other party said, well, yes, you will. Well, they have nothing to stand on, nothing to take to court to prove that there was a contract at all, therefore unenforceable. So, contracts conveying real property must be in writing to be enforceable under the statute of frauds. Let's skip the next one. We'll come back to it. Option contracts must be must be in writing to be enforceable. An option contract, what do we mean by an option to purchase? Any idea there? Option to purchase? What am I talking about? Sounds simple, maybe. With an option to purchase, you're buying some time. A buyer says, okay, seller, you have some land near the I-85 interchange where it's going to come through back in the day, true story. When I-85, the loop around Charlotte was being built, it crosses over Rocky River Road. And my dad grew up and had his parents' 8 acres, about a mile from where it was going to cross. Let's say that that property went all the way over to where the interchange actually ended up going. And so before they built it, there was land there that we owned as a family. Let's say a buyer, investor, who knows that eventually there's going to be a gas station and a McDonald's and whatnot. It's going to be valuable when that 485 exit gets put in right there when it finally does cross Rocky River. Therefore, they're waiting, though, because maybe the zoning is still in question. Maybe they're deciding, is it going to be right there or is it going to be further down the road? Maybe there needs to have some sort of a zoning change, still up in the air. So they're not 100% sure if they want to commit to buying our land yet, because they're not 100% sure if our land is going to be the right location. They could come to us and say, we should know this within the year. Therefore, I would like to give you a $10,000 option fee in exchange for you not selling it to anyone else and giving me the option to buy it if I choose to. So that investor would be buying the option to make a decision later. They're buying a choice. And then we would have to just sit back and wait. Once we sell them the option to purchase and take their money, an option fee, then it's a unilateral contract. We just have to wait and see what they want to do. They might say, yeah, I'm going to go ahead and buy it. Now let's do this contract deal. I'm going to buy it for such and such. Or they might say, you know what? They changed the zoning, or they decided to build the actual interchange 5 miles down the road. Your land is not going to be part of it. Therefore, I don't want your land anymore. I'm not going to exercise my option. I'm still out the option fee, though, because I was buying the amount of time to figure it out. Does that make sense? That's what an option to purchase is. It could also be, you might be tempted to think of it like a tenant who's renting a place has the option to buy it. But that's called something a little bit different. When it's a non-resident, non-tenant thing, we call it an option to purchase. When it's an actual tenant who's living there, then deciding to go through with it and wants to pay for the option to decide later, it's called something else, and we'll get into that in a future chapter. So that's an option contract, which also must be in writing to be enforceable. Oh, you gave me the option to buy this. Did I? We might have talked about it verbally, but we never signed anything, put anything in writing. Therefore, I dare you, sue me. You got nothing, no proof. We didn't put it in writing. Not enforceable if it's not in writing. All right, this one in the middle. Think more in terms of commercial real estate. That's good, Shane. Speculation on rising and dropping costs. That's the whole point. Yep. If it's a lease for more than 3 years, not 3 years or less, but specifically longer than 3 years. So if it's leased for 3 years, this does not apply. But if it's a lease for more than 3 years, this matters. If the owner of this, say, commercial property sells to a new buyer, new owner, the tenant who has a lease longer than 3 years, that tenant could end up getting booted out by the new person unless it's in writing and therefore enforceable. Unless the lease is in writing and therefore enforceable. If the tenant is there, if it's a 3 year or less than 2 year, 1 year, 3 year or less lease, there's some automatic built-in protections that's going to keep that tenant from being able to be booted, even if it's not in writing. That's a whole other story with landlord-tenant stuff. But leases lasting longer than 3 years fall under the statute of frauds and must be in writing in order to be enforceable. That's the limit of what you need to know there. But be careful about the test question, whether it says 3 years or less or more than 3, because the law is longer than 3 years. Leases for longer than 3 years, in order to be enforceable, must be in writing. So those 3 things fall under the statute of frauds. UETA stands for the Uniform Electronic Transaction Act. It's the thing that allows us to do things electronically, right? Brilliant statement. It's what lets us get our clients to sign electronically. We can do DocuSign, Dotloop, Adobe, all the places that have all the software that allows for electronic signing, and that's a huge part of the business. It is rare that we have to drive across town to get somebody's real actual signature. We can just send it to them in their email. They can authorize, yep, this is my signature, and they can click where we indicate they click, and it puts their initials, puts their signatures in the right spots. That goes fast. Sorry. Thank you for that. Why is it? What happened there? Apologize. There we go. And oh, gotcha. There we go. Okay, we just spent time on this. That's what I thought you were seeing this whole time. If you need to take a picture and make a screen cap, I'll give you a second to do that. That's the statute of frauds. Contracts for real property, leases for longer than 3 years, and option contracts all must be in writing to be enforceable. You bet. I have no idea how that got mixed up. And then the Uniform Electronic Transactions Act allows for electronic signing and allows for sending things electronically. They're still okay. They're still valid. An e-signature is binding and creates a contract. Doesn't have to be what's called a wet signature, pen to paper. E-signatures are allowed under the UETA in North Carolina. What can make a contract die, or what can discharge a contract or terminate a contract? Well, our favorite one is what? Which situation, circumstance is the best way for a contract to be done, be gone, be done, be terminated? Yeah. Completion, full performance, executed. That's the one we want the most. What are some others? Any other guesses? What else might kill a contract, make a contract go away? Some sort of operation of law. Impossibility of performance. People can't actually do stuff. Yeah, fraud. Bankruptcy. A minor. 18, sane and sober. Those voidability issues. They could kill a contract. What's an assignment? Any guesses? What do we mean by assignment? Can you assign a contract? What does it mean to assign a contract? Have you ever watched an investment real estate commercial or had been in a course and they say, we'll teach you how to make money in real estate without actually having to buy real estate? That's what this is. The idea of an assignment is you find, and it goes back to those bandit signs, those yellow signs on the street corners of the CVS and McDonald's, and they say things like, we'll buy homes for cash, immediate offer, close whatever, week close in a week, close in a day. They're trying to get sellers. They're trying to find sellers who are desperate, sellers who are highly motivated because of probably a financial problem. If they can find a seller who's motivated, who's interested for whatever reason, to agree to it in writing in a contract to buy the property at enough of a discount, then they have a pretty valuable document in their hand. They have the promise by somebody to sell their property for a price that's below market value. And so they'd try to negotiate it, who knows, maybe even half, pennies on the dollar, half the market value, or even 60, 70% might be the most they'd possibly want to be willing to do such a thing. They're going to have enough of a discount from what it's worth on the open market because the seller's willing to take a hit on it. And then they're going to call their investor buddies and say, look, I got one. I can't close on it. I don't have the ability to borrow the money, or I don't have the money myself, but it's a great deal. Check it out. And if you agree, I'll sell it to you. I'll sign it to you for $10,000, $5,000, $1,000. Still better than what they had. And what did they do? They cultivated, reached out, tried to find desperate sellers, found one, got him to sign a contract, handed that contract over, assigned it to a different buyer who is going to go through with it. Now, that seller might get confused when they go to closing and they don't see you. They see the person you assigned it to. And unscrupulous people did it poorly and assigned it to people who then in turn did not ever execute and perform. And so it ended up harming that seller. So in our standard offer to purchase 2T, it does say that assignments are allowed, but only with the seller's disclosure. You got to tell them what you're doing. You can't just assign it secretly and surprise them. Surprise, it's not me, it's this other buyer because I made a quick $8,000. Please do. Go ahead, Margie. I'd imagine that also was the case with athletes, any wealthy, anybody that might want to be able to buy with the privilege of not being charged the rich tax because they know that they have the money, so much money. It's basically a substitution of parties. You're agreeing the assignment of properties is not, as long as the assignment is not prohibited in the contract. And in our standard 2T that we'll look at, it is not. It's allowed, but full disclosure is required. The first buyer that made the initial offer is the assignor, and they assign the contract to the assignee, which is the replacement or secondary buyer. But here's the caveat. That first buyer, the assignor, remains secondarily liable for performance. If buyer number 2, the assignee, doesn't go through with it, there's still some liability on the shoulders of the first buyer. Kind of helps protect that seller from somebody just wasting their time, right? You'll see a phrase 2 places in our standard form. It could show up in other contracts, but in our standard 2T, there are 2 locations that you'll see this phrase. Time is of the essence. Time is of the essence is a legal term that means hard and fast date and time. If you go past this time by a second, it's over. Sorry, not going to work. Time is essentially of the essence, right? That's called a hard date. There's no wiggle room. There's no leeway, no tardiness allowed. If you're tardy past that date, it's not going to work in your favor. But it's got to have the words time is of the essence for that to apply. If it doesn't have the phrase time is of the essence, then time is not of the essence. It's not a hard date. There's a surprising date on the contract that you might be surprised to find is not time is of the essence, and that is the settlement date. When we make an offer and propose a settlement date, we're just telling them, look, we're going to try, but it's not a time is of the essence date. That's not one of them. The time is of the essence dates are these. One of them is the due diligence deadline. That due diligence period. The amount of time during which the buyer can back out for any reason or no reason. That's something to think about. Write it down. Buyer can back out during the due diligence period for what reason? Any or even no reason. They could wake up one day during due diligence and say, you know what? That was silly. Never mind. I'm out. And you call the agent and you say they're out. And they say, why? Doesn't matter why they're out. No reason is good enough. But what's the penalty? What's the cost? Walking away from the due diligence money. The due diligence money. So that's the only date, one of the only two dates that is time is of the essence. Notice right below that, the actual closing day, also known as settlement date. We'll talk about the difference in a minute. The settlement date is when everybody's going to sign the paperwork that we've been working toward this whole time. And once they sign the paperwork, including the seller signing the new deed and the buyer signing the loan paperwork, if there's a loan, and both parties signing the settlement statement, which outlines every dollar and cent in the transaction on both sides, debits and credits. That's when we're signing all that stuff is on the settlement date. You notice there is no time is of the essence there, and it's because settlement dates frequently get delayed for various reasons. Sometimes it's the lender who needs more time to process the loan. Sometimes it's the parties because they couldn't figure out or negotiate repairs. Maybe repairs didn't get done as promised. Maybe the buyer had the inspections before the due diligence period. They told the seller that they wanted the deck to be fixed and repaired because it's loose. It's not attached to the house, and the seller didn't do it. And so closing date comes, we have the walkthrough and the deck is still loose. Well, the best leverage a buyer has to get something fixed is to not show up, to not actually go through with the closing. But it's, many times a buyer has way more on the line than the freedom to just not close on it. Sometimes a seller won't fix things and says, well, I dare you not to close. Are you really going to not close? Your moving truck is full. You'd have to pay money to the mover to unload and reload, and your loan got approved. The lender would have to redraw the loan documents, and it's probably too late when it's an hour before closing to then have a buyer put their foot down and say, you didn't fix this, so I'm not closing. Yeah, okay, I'm going to call your bluff. As a broker, that's why I suggest let's go do the walkthrough with enough time for the seller to actually go through with the repairs that they promised, so that the occasional seller that tries that nonsense doesn't get away with it, right? Well, that could be an example of a settlement date getting pushed. The buyer could say, well, we were supposed to close today, but I'm not closing. And the seller says, what? I can't get anybody out there to fix it until Monday, and it's, say, Friday. That's your problem. You should have done that last week or whatever, right? So we bump that settlement date. And later in the contract, you'll see that we're allowed to fiddle with that settlement date for good reason for as many as 7 days without having to rewrite the whole thing and agree to a further date. But it's got a built-in 7-day buffer period for just such an occasion, for things like that that could cause delays. That's the pretty far cry from time is of the essence. It even has a built-in. It would be a mistake, though, to assume, okay, settlement date is this, fill in the blank, but we really have 7 days past that. The commission doesn't want us to handle it that way. Those 7 days are precious. They are there in the remote chance that, or the chance that they're needed, and it's got to be for a good reason that we're delaying. But time is of the essence is attached to the due diligence period because that has money tied to it. What money is tied to the time is of the essence? Due diligence period. What money is tied to this due diligence period? What money matters if we go past the time, the deadline of 5 p.m. on the date, fill in the blank? There it is, earnest money. And I jokingly say we really should call it an earnest money period, because it's not the due diligence money that you might get back. It's the earnest money that you're going to lose if you back out after this deadline. Now, I know we call it due diligence money because it's tied to the due diligence period, because you're literally doing your due diligence in deciding whether to buy it or not. But if you go past this 5 p.m. date to 5:01 p.m., for instance, and then you decide to back out, then the buyer is also losing the earnest money, right? That's what time is of the essence means. The other place that we find it is up here under additional earnest money. We can give them earnest money in a couple of different ways. And the difference between initial and additional earnest money is just about the time that it's due. It's about the deadline of it, not about whether you gave them money first and then you're giving them extra money later. So it's not the best naming convention that they've adopted here, but you'll notice initial earnest money is given when? Either by the effective date, which is the date it becomes a contract. Everybody signs and dates. Changes are made and initialed. That's the date when the last of all the signatures and initials that's done is dated. That is the effective date. So either by then or within 5 days of the effective date. If you can promise to give them earnest money either effective date or within 5 days, then we'll use this one. We'll use initial earnest money and write that dollar amount we're going to put out to the side of this one. But what if you say, you know what? I don't want to give them the earnest money yet. I don't trust that if it needs repairs and I back out during the due diligence period, that they're going to sign the release to give me my earnest money back. Remember that? When we talked about how the seller could actually kind of hold that money hostage, refuse to sign the termination, even though it's mentioned in the contract that the buyer's supposed to get it back. Seller could say, well, I don't care. I'm not signing the release form. They can hold your earnest money hostage. That might matter to a first-time buyer who needs that earnest money back so they can go buy the next house, buy the house that they're going to replace this one with, right? And now they're not able to go on with their plans because their $5,000 earnest money is tied up because the seller is unfairly angry about it and won't sign the release. How can we protect that buyer from that situation? Instead of using initial earnest money here, we'll use additional earnest money. Don't even use initial at all, because look what it says for additional earnest money. When is it due? No later than 5 p.m. on, you name the date, fill in the blank of the date of your choice. But the trick to it is that is a time is of the essence deadline, right? That way, let's get creative. Let's set that date that we're going to give the earnest money over, that buyer's going to have to write that check and turn it in. Let's set that date to the due diligence deadline itself. That way we've had the inspections. The buyer decides, I don't want to buy it because I'm scared now. And they can back out. And the seller says, well, I'm not letting you have your earnest money. And the buyer's like, you have no say over that because there is none yet. I didn't promise to give it to you yet, so I didn't have to give it over yet. Therefore, you can't hold it hostage. That's this other place where time is of the essence is important. Because if you're using this tactic with this additional earnest money, it better be in on time or you have troubles, you have problems. So time is of the essence is in 2 places on the contract. That's what those things mean. There we go. So all dates that do not specifically say time is of the essence are considered target dates, not hard dates. This concept of novation is when you're substituting with a new contract. You're avoiding the existing terms without breaching the contract. It's the same or maybe some additional parties. It's intended to terminate the old contract but have a new one ready and in place because maybe we're trying to neaten things up or we've gone back and forth with negotiations so much that we want to make sure to be clear and have a nice, clear new contract to move forward with that everybody is 100% on board with and understands. Maybe you've marked through the The warranty, that the seller will provide a warranty, and then another negotiation round, they said, no, for this price, I won't give one. And it's unclear on the contract because of all the strike-throughs and initials. And so you say, let's do a novation. Let's substitute with a nice, pretty version. Get it nice and get it in a way that it's clear for clarity's sake. A novation is supported by something of value, by consideration. It needs to conform to the essential elements of a contract. But it's this idea of substituting a new contract. Interpretation just means that preliminary negotiations are not admissible in court if they don't make it to the contract. Somebody might say, well, you promised you would do this back when we were talking back and forth. Yeah, but did it survive and make it into the contract? You said you'd leave the chandelier, but if we didn't put that chandelier in the actual contract, you got nothing to stand on, because it needed to have made it to this place. Where'd it go? There's our fixtures right here. You said you'd leave the chandelier. It's a fixture. Well, no. Where'd it go? There we go. It was this one. Items that do not convey. Chandelier should normally stay, but we're going to have that in there and take it with us. If you didn't manage to write it in there, then that chandelier has to stay as a fixture, because it's considered a fixture unless it's mentioned here specifically that it doesn't stay. So it doesn't matter what you said back and forth up front, but if when you finally filled out and wrote the final contract, if it doesn't make it there, that's what puts a lot of pressure on us as brokers. Let's make sure all of those back and forth little negotiations survive and make it into the actual contract that gets signed. Because guess what? If it doesn't make it there, you might be buying a chandelier or a refrigerator or a stove or whatever the case may be. The written contract rules the day. Here's another one. In the MLS, sometimes the seller will say in the remarks, what they'll say? The pool furniture stays with the house. We're leaving it. The storage building is also included, and a home warranty is provided. And when the contract finally gets written, if there's no pool furniture mentioned, no storage building mentioned, and no warranty mentioned, then you don't have any of those things, because the MLS is not the contract. It's considered advertising. Just because the seller promised it in the MLS remarks, if it didn't get to the contract itself, then you've got nothing to stand on. Now, that buyer might be mad about it, and they would probably talk to their buyer agent and say, you're the agent. You're my buyer's agent. You should have caught that, made sure those things got in there, because I have proof through emails that I wanted them. You said that they would be included, and then when we finally wrote the offer, you forgot to put them in, and I signed off on it just trusting that you did it right. Now, that buyer agent might end up having to deal with some stuff. They might need to buy some things to keep that buyer happy. They might end up getting turned into the real estate commission because they didn't do their job to the proper level of professionalism. But the seller's off the hook because it didn't make it into the contract, right? Interpretation of contracts also must be reasonable. They're taken as a whole as opposed to looking at individual parts. They're looking at the whole contract, and words must be interpreted in their ordinary meaning. Can't get fancy like pay a high-priced attorney to say, well, it depends on what the word is means. Depends on what the actual word might mean. It could mean this or that or the other. None of that nonsense. Words are interpreted in their ordinary meaning. And then any sort of ambiguities, lack of clarity, is going to go against the one who wrote that language that is ambiguous. Any ambiguities are judged against the one who wrote them. They shouldn't have made them so ambiguous. They should have made them clear, easy to understand. So they take the hit. They're going to suffer for their lack of clarity. The parole evidence rule says that our verbal agreements don't matter if they don't make it into the contract in writing. That's the parole evidence rule. Put all terms in the contract. Yeah, but I negotiated up front. We said so. We promised. In verbally, we shook on it. Doesn't matter. Got to get into the contract or you have nothing enforceable to stand on. What happens if a contract is breached? The idea of breach means you didn't honor the terms of the contract. So if the buyer breaches versus the seller breaches, what is at stake? Anytime you're in a court of law, there's different kinds of damages talked about. Compensatory damages are used to make the party whole again. Party suffered, how can we make them whole? We award them compensatory damages. Consequential damages are given to make up for lost profits that you suffered. If it's determined that you're going to, let's just rescind or have rescission, that puts you back into your original starting position. Not trying to get anything extra. I just want to get back what I had to start with, return to our original positions. In North Carolina, we have what's called liquidated damages, and that is what is available to the seller when a buyer breaches. What happens when a buyer breaches? It's the one on the bottom here, liquidated damages. What is the liquidated damages that are already included and built into the contract? Two items are considered liquidated damages that the buyer has pretty much already given over. They've already given up. And those two things are the due diligence money and the earnest money. That seller acknowledges in our standard offer to purchase 2T that if the buyer breaches, the remedies available to them are limited to the earnest money and the due diligence money. So that means you better counsel your seller when you're a listing agent. Are you sure this is enough earnest money and due diligence money in the event that maybe a week before closing that buyer just randomly changes their mind and backs out? Because that's all you're getting. You better be happy with it. These last couple of years, they probably were happy with it. But once upon a time, not long ago, my advice when people ask, how much do I write the checks for, earnest money and due diligence money, my advice was about 1% of the purchase price. That should cover both combined earnest and due diligence, and that was usually good enough for most sellers. But that's not the case anymore, it seems, because the market has become what it is. And so that's a much bigger deal. Sellers are, back then, they might not have been happy with a couple $1,000s if that buyer breached. Now, $10,000, the buyer breaches, they might not lose sleep over it. They might welcome the chance to get a new buyer with even as much or more due diligence money, right? So liquidated damages spelled out in the contract available to the seller if the buyer backs out, breaches. Those are earnest money and due diligence money. That is what is available as a remedy to the seller if the buyer backs out, breaches. What is available to the buyer? We talked about it earlier. The buyer has the right to sue for specific performance. The remedy available to the buyer is to sue the seller to specifically perform, give money in exchange for that property that they are refusing to sell because it's a unique property and it's a big deal. That could add up a lot because land is unique. And by the way, they could also sue them to get reimbursed for everything they spent in the transaction, like inspection fees. Let's talk about that for a second. There's a general inspection that usually runs about $500 or $600, depending on size and age of house, could be more. That general inspection could say, well, looks like there might be signs of fungal growth. We recommend a specialist, basically get a mold guy out there. Well, the mold inspection is going to be another $300 or $400, and that's not even including taking samples to send off, which are $100 each. You could be at $800 to $1,000 with the mold inspection real quick because you want them to scrape a little bit off and send it off to see which species of the hundreds there are, because maybe you're only allergic to one of them. And then also if they take an air sample, they've got to take one from the outside to compare to the inside. So that's built in automatic 2 air samples required. And maybe it's in the basement as well as the main living area too. It can get crazy. So now we're at mold, we're at standard inspection. Oh, also we need a structural engineer's letter because there's a crack in the foundation wall in the basement. Well, there were 500, 800, 1,000. Those inspections can add up quick. and that seller is breaching after that buyer has gone through all this stuff, and the seller's just saying, never mind, I'll just keep it if it's going to that much trouble. The buyer's like, well, no, you're not, because not without giving me money, because I've spent $10,000-$20,000 between that and the due diligence money and the earnest money, because I didn't figure all this out, decide to leave until after due diligence is over. And I'm not leaving. It's not that the buyer's leaving, it's that the seller won't sell. So that's the remedy available to the buyer when the seller breaches. If a buyer refuses to close on a contract, the seller can sue them for specific performance. True or false? You guys are good. You didn't just, it's late in the day. We're almost over. And I'm sure you're a little groggy. You didn't fall for it. Good job. Yeah, that's not the remedy available to the buyer or to the seller. That's the remedy available to the buyer. So if the buyer is the one who refused to close, they're the one who's breaching. The seller doesn't sue them for specific performance. The seller would need to be happy with the liquidated damages of earnest money and due diligence money. That's what they're getting. But if in opposite of this, the seller breaches, then the remedies available to the buyer would be suing for specific performance. Good job. We flipped it on you. Don't forget, we as brokers can't practice law. When it comes to contracts, we are allowed to fill in those blanks. There's a lot of them. They've designed it that way. All these blanks we're authorized to fill in with the proper kinds of possibilities. We can't get super creative, though. Certainly not down here over the Addenda section. You can't say, check the box, see Addendum Z, and on Addendum Z, you, the broker, got crazy and you wrote about 10 items that the client wants you to include. That is not for you to do. Who can write a brand new, fresh addendum? Who can get fancy with extra language in the blanks? An attorney's their best bet. Let's see what the attorney says, because, yeah, we can all roll our eyes and say the attorney's going to make it more complicated, but many times they kind of need to. It needs to be made more complicated to cover all the bases. And it might not be so simple as just writing that one sentence that the buyer wants in there, because that sentence opens up a lot of other possibilities that we also need to limit. Best choice is lawyer, attorney. Also allowed, though, are the parties to the transaction. The buyer and the seller themselves could write the language. They're allowed to because it's between each other. You, the broker, are not allowed to. So if they ask you to write up an addendum, what are you going to say? I'm not an attorney. I can't do that. You could, and then I'll attach it and reference it here. And then other blanks, we are just allowed to fill those in as needed with the proper information. We just can't elaborate. We can't do what's called practicing law without a license. We can't draft legal language. That's the main thing. We can't give legal advice either. Once upon a time, may have mentioned it, I had a friend, and she was an adult living with her elderly mom in a townhouse, and the mom's name was on the deed by herself. But in the meantime, my friend had taken out a refinance. So she and the mom were on the loan. She was obligated to pay the loan along with the mom, but her name was not on the deed. The mom was elderly, and she was just wanted to make sure things were in a row. So if the mom did pass away, she wouldn't have trouble. And I said, well, you're talking about either adding yourself to the deed, having an attorney do that either as a tenant in common or a joint tenant. Those are the two possibilities. Now, here's an attorney. Go talk to them and find out what their advice is to you about which one is which and what makes sense for your needs. My guess was tenants in common. That's what it needed to be. Obviously, it wouldn't have been tenants by the entirety because she didn't marry her mom, right? So I never knew what she did. I just kind of let it go, and I'm like, I hope she did it and got it done, got that buttoned up, because 6 months later, her mom was actually diagnosed with advanced cancer. And within 2 more months, she was gone. And fortunately, I did find out that she did, in fact, go through with it all. And she talked to that attorney and had it drawn up. So it made that whole process much easier. They gave her the advice. She signed the new deed with both names, and it just made that estate probate process all the more easy. Otherwise, she would have had to jump through some more hoops. I didn't give her legal advice. I told her what things meant, and I pointed her to an attorney to give her the advice. We could fill in the blanks on the prepared forms. And by the way, testable question, who can use these forms? This 2T form, for instance, that I'm showing you. And on, what day are we on? On Monday, we'll get into 10, and I'll show you some addenda and amendments there that were also prepared by the Realtor Association in conjunction with the NC Bar. So the only people allowed to use these forms with the Realtor R logo are North Carolina attorneys and North Carolina realtors. If you give us a form, like instead of the one that has sample on it, like we're looking at, but a blank one that has no word on it, like sample, if you just give that to a for sale by owner to just kind of win them over and maybe have a shot at listing it if they decide to give up and they try to use it, it would not be okay for an unrepresented seller to sell to an unrepresented buyer, no realtor in sight, and they use our realtor form. That's not allowed. So those standard forms that we use must only be used by realtors and attorneys. If parties want to change the terms of a contract, you're under contract, they will use an additional provisions addendum, true or false? They want to change the terms of a contract. We are under contract. This is not an offer, but an actual contract. What do we do to change terms? We don't use an addenda, an additional provisions addendum to change terms. We don't use addenda to change terms. We use addenda to add to initial offers. We would use the amendment. Amendments are for making changes to an actual contract. Addenda are used to add terms to offers in the beginning, up front. So to change the terms of a contract, we would use something called an agreement to amend. It's an amendment. It's not an addendum. So this would be false. Questions? Okay, let's recap here about offers and contracts, offers and acceptance. An agent helping the buyer as a subagent to the seller. Let me ask it another way. The selling agent is an agent helping the buyer as a subagent to the seller, and they write an offer and they present it to the listing agent. Did I just lose you? Because sometimes you'll see that phrase. The selling agent helping the buyer as a subagent to the seller. What does that mean? When I say the selling agent helping the buyer as a subagent to the seller, what is it? Where did you get that from? When I say selling agent, it means the one that's helping the buyer, because we know selling means buyer's side, right? That's selling. You just got to have that in your head. I can't think of any rational reason to help you remember it, because I could see validation on either side, or help remembering it on both sides. But selling means you're helping the buyer. So it's kind of redundant. The selling agent helping the buyer as what? We don't know. We need to know more information. As what? What are the two ways that a selling agent could help a buyer? Let me ask that. Selling agent helping the buyer is either going to be doing so as a buyer agent or as a subagent to the seller. They're helping the buyer either way. But in this case, they've actually had a signed buyer agency agreement. If they don't have a signed buyer agency agreement, then by default, they're this, subagent to seller. So a selling agent helping a buyer as a subagent to the seller. That just means they're on the buyer side and they don't have a buyer agency agreement signed. That makes a big difference because something we talked about today. We've got a buyer making an offer. We've got the little negotiation fence there, the imaginary fence. They have not a buyer agent, but a sub-agent to seller who's helping them because they refuse to sign the buyer agency agreement. They write an offer. They send it over to the listing agent. Listing agent forwards that offer over to the seller. Seller looks at it and says, yep, okay, I'll take it. So they sign it. Are we under contract at this moment in time? It's all about what? What word is it about? We're looking for when this happened. But what communication from whom to whom? Right? Communication from seller to listing agent isn't the communication we need here. That's all that has happened at the moment. Seller signed it and told their agent that they signed it. We are not under contract yet because we haven't crossed this fence. Once the listing agent calls that agent helping the buyer and says, look, my seller signed it. We agree. They agree. We're under contract. That sub-agent to seller would say, well, clearly you didn't read the contract on the last page where it says that I am not a buyer agent. I'm just a sub-agent to the seller. Therefore, give me a minute. Let me call my buyer real quick so that we can be under contract. You with me? It's all about the role of this person in terms of this communication. Who are they talking to? Listing agent communicated to a sub-agent to seller, then we're not under contract yet until that sub-agent to seller reaches out and communicates to the buyer and tells them, yep, seller signed it. We're under contract now. Now we're under contract. You with me? But if this person if it's a buyer agent that this buyer's working with, in other words, selling agent helping the buyer is a buyer's agent, sends the offer over, listing agent tells the seller signs it unchanged, seller tells the agent that they signed it, congratulations, but you're not under contract yet because that listing agent needs to now tell the buyer agent, now we're under contract. Oh yeah, but the buyer doesn't know. They're in the mountains. They can't be reached. Doesn't matter. They had a buyer agent telling the buyer agent is good enough. They better not come back from the mountains deciding to change their mind because they are under contract and they don't know it yet. They're not going to know it till they get back and are told, but they are because the communication happened to their buyer agent. See that difference? It's going to be a paragraph, sort of like what I just said, but written out. And you're going to have to say, they'll give you A, B, C, D, or 1, 2, 3, 4, really. It'll be like that. Which of these moments in time is the one at where it became under contract? And they might even start getting fancy and saying at 3 p.m., they made the offer. At 5 p.m., the offer was countered. At 6:30 p.m., the buyer accepted. Oh, wait. The buyer accepted the counter. Well, meaning the buyer signed it. Do we have a contract? The buyer has signed the counteroffer. They've accepted, and they told their buyer agent that they did so. Do we have a contract? Ooh, we haven't talked about this direction yet. We still don't have a contract because they haven't gone back across the line. It's this line that matters. They haven't communicated over the fence. They need to hit that ball back across the fence and communicate to the listing agent. Now it's under contract. You with me on that? The fact that the buyer signed the counteroffer is all well and good, but the communication matters. The communication. They tell their buyer agent, or maybe the buyer agent was standing there when they signed it. The buyer agent now knows and it has been communicated to, but that is not enough. That buyer agent needs to now communicate over to the other side, to the listing agent. Now we're under contract. You know what that means? It means you can take naps or have food. Food might help. I know it's a lot, but look at those test questions at the back of the chapter. See if they make sense. I'm going to go ahead and release the practice exams and get you started kind of looking at those. And then on Monday, I'll give you the midterm, which means we're not going to do it in class. I'll just send it to you. And then after class Monday, and then you can either do it on the screen, or probably best practice will be to print it out somehow and then circle the answers and then grade it yourself. And I'll tell you how to grade it and figure out what % you got right. And it doesn't matter. All that matters is it helps you understand, okay, where am I at? Now you're going to start applying what you've been learning to an actual test-taking scenario. And unfortunately, that is the way this works. I wish it was more of a hands-on approach. Here's how the business actually goes, but we're just subjected to a testing process. So unfortunately, it's all about, is it on the test and can I pass the test? So we're going to start talking about test-taking strategy more. And as you see those questions, go through a couple of them between now and Monday with, don't cheat, right? Don't get the full testing experience by going through the whole thing somehow, even if you have to lie and say, I'm going to Walmart, and you actually sit in the Walmart parking lot and take this test, because that's the only way you get an hour or two of privacy. Get some privacy, take the test from beginning to end, see how it goes. And that whole back and forth of, agonizing decisions. Is it C or is it D? I don't know. Make a call, pick one, go through the whole test before you then look at the answer key, because I'll send you those too, and see how many you missed. And it will be more than you hope that you missed. You'll do worse than you think you're going to do, because it's natural to apply the content to the actual test taking process. That's okay. Don't worry about it. Don't get stressed. We'll work you through that. And let me know if any questions. Use Notion, and I'll see you on Monday. Okay, good talk, guys. Chapter 9 is in the books. We're going to move on into Chapter 10 on Monday, but in the meantime, don't forget, I'm going to send you practice exams. I would highly suggest you go through at least a couple of them between now and then and grade them. Take the whole exam beginning to end. Don't look at the answers one by one. It's tempting to do that. But put yourself through the agony of choice. That is something, a real experience you're going to have in the real test-taking moment. So go ahead and get used to that. Get comfortable with it. Like running a marathon and running further than you're going to have to run in the race, right? During your practice. So let it be painful. Don't just look at the answer in the moment. And what else? Come having read Chapter 10, we're going to dive into the forms on Monday. That is pretty much what Chapter 10 is all about. And then we're just going in order past that. Keep on going. We'll probably even hit 11 once we, maybe even on the same day. So look forward to seeing you there, and have a great weekend.